Hey, everybody. I'm going to wait a few minutes, make sure everybody found me. We are going back to Brooks because they are done with testimony in the Amber Alert murder trial. And the other one that we are going to do tomorrow when they get done with closing arguments is the hidden body murder trial. 55-year-old Matthew Paul is charged with first-degree intentional homicide and hiding a corpse after his girlfriend, 44-year-old Stephanie Pavlons, was found in a wooded area near Delafield, Wisconsin. Pavlons had been missing for 3 weeks before her body was found. Investigators reportedly found video footage showing Paul and Pavlons leaving their apartment together on August 22nd, 2022, and Paul returned to the apartment alone, carrying the victim's belongings. They also said Paul searched local obituaries, read online articles about the investigation, and pretended to be the victim online. The defense team tried to get the whole case thrown out in 2023, arguing that no one knows how the woman died. Paul had pleaded not guilty to the crime. If convicted, the first-degree intentional homicide charge carries a mandatory sentence of life in prison. So that is the one that we will be doing tomorrow. Wiggle stole your Z. Well, that's what you get for being awesome, Marty. People steal stuff from you when you're awesome. Guess who's back, 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 back again, again. Guess who's back? Guess who's back? Guess who's back? Guess who's back? Only Eminem song I like. Okay. Don't. Is there no sound? Sound. I've tried to unmute it 3 times now. Unmute. Why did you start over? Don't start over. Where were we? I didn't tell you to start over. We were on day 12, right? Right after his big scary stare. Nope, he's in the other courtroom there.
Yeah, I know, it's just not there. I saw it, it's fine. But only as to flight.
Okay, I gotta figure out where we were. Oh, cool. I guess I should put up there what I'm saying oh cool about. Okay. She was standing when she said
Injuring bailiffs provide the parties. We have a letter regarding sequestration. There's an emergency contact form. So
wait, were we on day 12? Weren't we on day 12?
Stop the call from Polycom to Polycom, and then I'm going to call it in through the Zoom.
No,
and that he is not going to testify. So once again, I am unmuting him.
What day are we on?
Nissa,
out here.
National Highway Traffic and Safety, I think, Administration. There are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recall.
What day were we on? Shoot.
Brought him, I should state it this way, he is not in this courtroom presently because on day 15 of this trial, and specifically this morning, right, we have a history.
Day 15? Were we that far?
Thank you, everyone. Please be seated.
This is day
Just
12.
for the record, Mr. Brooks is appearing from another courtroom. That should not affect your deliberation or verdicts in any way. At this time, does the state have any, right, thank you, ma'am, you may step down. Thank you for being here. Conviction for resisting, obstructing. There was a misdemeanor bail jumping dismissed and read in. And then the other charges.
Do you recall seeing the?
He has prior criminal history,
Thank you.
so as long as the jury is out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
That's not how it was said.
That was how it said. You want to run the record back?
This is.
Thank you. Thank you. Just gonna have that brought back out. I took it with and I left it on my desk.
I take notes in live
And
trial.
then
I don't in the
remind me the statute again on priors.
$90609.
And a copy of the record was provided to the defendant.
It was. It has not been discussed with Mr. Lozano.
That was going to be kind of my next topic once, thank you, I look at this again. All right, Mr. Brooks, do you have a position on the prior state is asking for a determination by this court that there are 7 prior convictions for purposes of questioning the witness, whether that's by you or by them if they so choose. And that would be for a determination under 90609.
What did we miss?
Texting anyone?
Yes.
Do you recall who that was?
What did we miss, Judy?
Obviously. I see the whole strategy here by the prosecution.
He pounded his face.
And then she stepped down. Oh, okay.
All right, then.
We need to complete the task of.
Oh, we do.
flyers for Mr.
I knew I would left some.
Everything.
I can't ever get it right at the spot I want it. Well, hello. Can I? Shadow? Can you please? Thank you for your assistance. But you screwed it up. But thank you for trying to help, honey. Are we still on the same video? Did you change the video? Please tell me you didn't. Please tell me it's still on the same video. I don't think it's the same video. Did you change the video, Shadow? How did you do this? What day is this? Shadow, you changed the whole day. I just got it to the right part. I'm turning the keyboard off now. If you step on it again, it won't mess it up. Here, you. Ugh. Come here. You're trying to help Mommy find the right spot? Well, guess what? You screwed it up. Oh, and you've made me incognito on the laptop. I don't know how to undo that. Can you undo it for me? What are you doing? Can you look up here in the camera and say hi? Look up here in the camera and say hi, everybody. Say hi. Say hi. Have you been calling Misha too? You call Aunt Judy and Misha when I'm not around, huh? Look up here. You're not gonna look? Huh? I don't want to go incognito, chat, though. I don't know how to undo it.
They were before. I'd like to continue by bringing the jury out momentarily, Madam Clerk, and having you call your next witness. I trust that you're ready to do that, sir. All right, then, Madam.
We need to complete the task.
Oh, we do. I knew I would left something in my office, but I reviewed it, so go ahead. That relates to the prior record.
We believe the proper answer would be 7 prior convictions, Your Honor, and that would not obviously be counting the OWI first conviction from 1993, which is at the top because it's the age of that, and obviously that would not have been a crime, but everything from OWI second on down we believe would be appropriate. There's also one that's noted, 06CM2039. It was a case, but all the charges were dismissed and read in, so we're not counting that file either.
Can you go run and get that for me, please? Thank you. Just gonna have that brought back out. I took it with and I left it on my desk. And then remind me the statute again on priors.
90609.
Thank you. And a copy of the record was provided to the defendant.
It was. It has not been discussed with Mr. Lizcano.
That was going to be kind of my next topic once, thank you, I look at this again. All right, Mr. Brooks, do you have a position on the prior convictions for this witness? The state is asking for a determination by this court that there are 7 prior convictions for purposes of questioning the witness, whether that's by you or by them if they so choose. And that would be for a determination under 90609.
What? I don't know what you're asking.
Mr. Brooks, you may recall at some point I believe we had a discussion about prior convictions. I think maybe we only discussed that if you were to testify, we would have to have that conversation. So in fairness, I don't
No,
think...
there was one state's witness that had one prior that we discussed. And
That's
the court
right,
ruled.
we did. I recall now. So at that point, I directed your attention to 90609, and then I made a ruling based upon the factors that are enumerated in that statute. You've been provided with a listing of the record. I would direct your attention to, I'm not sure if I see that book out there, but the statute book that I previously provided to you, but that the 90609 would be in there. But in any event, the state is asking that I make a determination about how many for purposes of the questioning of this witness, do you have any comment, statement, or position on that?
Looks like it's 9 on here.
Which is the one the state referenced that the charges are listed, but they were dismissed?
2000, well, it's recorded as 06 CM 2039, 2 times violate harassment / restraining order, and then it says DM / RI, which means dismissed and read in, 2X MBJ, which would be 2 times misdemeanor bail jumping, dismissed and read in. So no convictions from that file.
So why is it on the sheet?
This would be an accurate listing of the cases that you found when investigating the witness's background.
Yes, Your Honor.
And nothing since 2007.
That's correct.
All right. Any statement you want to make, sir, on what the number of convictions this court should consider under 90609?
What is dismissed and read in? Does that mean there is no charge?
No, it means it was when there was a conviction for something else, the charge was dismissed and read in, and then the court considered it at the time of sentencing. So they are not convictions, but it was a case. So that's why, my understanding why it was listed.
So the two. So where it says dismissed and read in, that would be the restraining order and the MBJ.
Right, misdemeanor bail jumping. So 2 counts of violate harassment restraining order were dismissed and read in, along with 2 counts of misdemeanor bail jumping dismissed and read in. I'm guessing, but the state can confirm that it either was read into 06 CM 1859 or 06 CM 3149.
Yes, I believe it was the 1859 case, Your Honor.
So at the time of the conviction for resisting obstructing, there was a misdemeanor bail jumping dismissed and read in, and then the other charges, all of which are listed under 06 CM 2039, dismissed and read in.
So then 8. Should be 8.
The OWI first would not be criminal, as I understand it, and so I believe that's why it's not, the state did not ask it, that it be counted. Because the statute requires conviction of a crime or an adjudication of delinquency.
So there's no crime for OWI?
An OWI first would not be a crime, it would be a forfeiture.
I still would say 8, just based on the fact that there's continued OWIs. All the way up to a 5th.
I'll remind the parties of the factors to consider for exclusion include the lapse of time since the conviction, or in this case convictions, the rehabilitation or pardon of the person convicted, the gravity of the crime, the involvement of dishonesty or false statement in the crime, the frequency of the convictions, and any other relevant factors. So based on that, do you have any argument that it should be less than that?
Less than what, 8?
Well, it'll be less than 7. He has 7 convictions as I count them.
And that's not counting OWI first.
Correct, because it's not a crime. It can't be counted under the statute.
Then it's 7. Should be 7.
All right. Do you want to make any argument about whether any should be excluded under the statute based upon the factors I just read to you?
Well, you already made reference to one of them not being a crime. So that brings it to 8. I don't understand the whole...
Well, for example, the last conviction was in 2007. It's now 2022. So do you want to make an argument to the court that perhaps he's been rehabilitated?
I don't want to speculate on the next man's life, but if it's 7 on here, well, I guess it brings it to 7. And whether OWI first is not a crime, it still counts as a what it essentially is nowhere to get to 2, 3, 4, and 5 without the first. Looks like 7 to me.
All right, then. Anything further from the state on this?
No, Judge, thank you.
Given the number of convictions, factually, although the first one's not a crime, the OWI first, Mr. Brooks is correct, is from 1993, and without that you don't get the other criminal OWIs. But I would note the record is from the criminal record is from 1997 through 2007. That spans about a 10-year time span. It's now 2022, but there's essentially an agreement by the parties that there are 7 convictions that are listed here. I've looked at the lapse of time since the convictions. I don't know about rehabilitation or pardon, other than it looks like he did complete the earned release program, which would have resulted in a reduction of initial confinement and then converted to extended supervision. I don't see violations of probation listed, meaning that he was revoked. I see some extensions, but that could be for a variety of reasons. But given that there was a pattern with the OWIs, that the last one was a felony, that goes to the gravity of the crime. And the other issues, I'll find that for purposes of his testimony, that this witness has 7 convictions. He may be asked, have you been convicted of a crime? His answer should be yes. And then the follow-up, how many times? The answer will be 7.
That will have to be told to Mr. Lozano before he testifies, Your Honor, I believe.
I agree. State willing to relay that information?
I'd rather not, given the accusations levied by Mr. Brooks. I think it's better we do it in open court, Your Honor.
All right. Who's your next witness? Will it be Mr. Lozano? Because if it is, I'll just have him come in now and I can put him on the stand and advise him of that.
May I ask who's present right now?
Well, for sure, Mr. Hayes and Mr. Lozano, and I'm not sure the 330 witnesses, I think, are probably on their way. They're on their way.
All right, so Hayes and Lozano are still here.
Yes.
All right. Those are the 2 who are here, sir. I'll tell you what, either way, let's just bring Mr. Lozano in case he's not your first, but then I don't have to deal with the interruption with the jury. You don't have to call him first unless you want to, but I'll just bring him in and advise him. So if someone from victim witness could bring him in, please. Can I have a first name for this witness, please?
It's
Abel, thank
Abel,
you.
but I believe it's pronounced a different way. It's Abel. Abel.
Abel, thank you.
Abel.
Subject matter jurisdiction, Your Honor.
Court declines to address that.
Still has yet to be verified and proven for the record.
Your objections noted for the record. Do you want Mr. Lascano on the stand, or are you going to call Mr. Hayes first? Just so I know what to do when he comes in.
I don't currently have, I can't find paperwork from Mr. Hayes. Can a police report or something be provided in case I want to call Mr. Hayes first?
Yes, we will accommodate that request. It'll just take me a minute, Your Honor, to find it. I'll have to have it printed and brought over, or Mr. Witchow can run. Thank you, Mr.
I will give you
Witchow.
permission to email it to Teresa, and she can print it in the courtroom.
Well-
That will assist.
It's part of a 700-page PDF, so I can't just email one page.
I see.
At least I don't know how to do that. Copy and paste it into a Word document. I'm ready.
That's all right. You can do it the way that you need to. All right. Mr. Lascano, I'm just going to have you, for a moment, take a seat. You're not going to testify just yet, but just come up and take a seat just at the end of my jury box for now. I'm not going to have you come up to the witness stand. Everyone can have a seat. I want to advise you that I'm aware you have a prior record. And so for purposes of testimony, I've made a determination that if asked, have you been convicted of a crime? Your answer should be yes. And then if someone asks the follow-up, how many times? The answer to that is 7. Have you heard me say that?
Yes.
Do you understand that?
Yes.
All right, thank you. I'm not sure that you'll be called next, but I wanted to do that while I didn't have the jury here. You can go back out into the hallway then. Thank you. All right, then let's have the jury brought out, please.
All rise.
Thank you, everyone. Please be seated. The defense may call its next witness.
Defense calls, is it Jason Hayes? Jason?
All right. We'll have the witness brought in. Is it Haynes or Hayes? Does anyone know?
No end, to the best of my knowledge.
Hayes? All right. Good afternoon, sir. If you would please make your way to the witness stand, which is on my right. Upper riser. When you get there, Please remain standing. Raise your right hand. My clerk, Teresa, who's across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. The first thing I will ask you to do is to state your first and last names for the record and spell each.
Jason, Jason, Hayes, Hayes.
Thank you. Go ahead, sir. Your witness.
Just 1 second. I accept for value and return for value this document for the record. Good afternoon, Mr. Hayes. Is that how you pronounce Hayes?
Yep.
What do you do for a living?
I'm a retail sales associate for a food broker, Damon Worldwide.
Been doing that for a long time?
21 years.
Yeah, it's a long time. The evening of November 21st, 2021. You recall that evening pretty well?
Michelle's here.
Very
Hey,
well, yes.
Michelle.
Went to the parade.
Go to the parade with family, friends.
I went there with my daughter.
Do you recall what time you arrived?
30 minutes before the parade started.
Were you scheduled to do any marching in the parade itself,
No.
or just spectating?
Yes.
Just for the record, did you say yes to being a spectator?
Yes.
Thank
That's
you.
what I thought he said.
Yeah, yeah.
I just wanted to make sure there was.
Yeah. He answered. He answered. Anything unusual catch your eye that day that you recall?
Car speeding
Yes.
through a parade. Yeah.
And what did you see?
You driving a
Besides
car
the parade,
Yeah, I'm sorry. That was unusual. That caught your eye that evening.
well, where we were, yes, a truck came through where we were. It honked and swerved.
I guess I want to back up a little bit. Where were you positioned at that
We
time?
were all the way at the beginning of the parade.
Okay.
Like, it was Main and corner of Main and White Rock.
Okay. And you said you observed this vehicle. Honked and swerved.
Yes.
What did it swerve from?
I'm sorry.
What did it swerve from?
Where?
Or was it? I guess the correct question would be, why did it swerve?
Why? Yeah, there you go, Darrell.
I don't know. I wasn't driving. I don't know what his intentions were.
Why did he pick the people that he picked to testify for him?
And you stated that the vehicle honked. Was that just a single honk, or was it a beep beep, or
One honk.
do you recall stating that it honked several times?
I don't
And
recall.
when you were initially.
I don't recall.
Getting these people off the police reports?
So, well, before we get to that, did you see where the vehicle went after it honked and swerved?
Yes, it kept on going straight down Main, east, the same route the parade went.
Did you get a description of who was driving the vehicle you saw that
I
night?
did not.
Did you get a license plate?
I did not.
Do you recall if the vehicle had any tinted windows?
No.
And I'm assuming at some point you either were interviewed by law enforcement or seek to be by law enforcement.
I did. Detective.
Evening or
It was not the same evening.
so
It was a
that
couple
days
days
prior.
after.
Yeah. Do you recall in that interview that you had with the detective stating that your kids were playing in the roadway and the operator of the vehicle honked the horn several times and veered to the left around the kids?
Yes.
Thank you,
So in
Mike.
your opinion, it wasn't trying to strike the kids?
Correct. Yes.
And after it continued, I think you said east.
Yep.
Would that be correct? East.
Yep.
Did you see the vehicle strike anyone? When
I did not. No.
Do you recall what side of the street the vehicle was traveling on at that
It was
time?
on
On the right side.
So we were on the north side of the road.
Okay. So the right side would be.
Yep.
Okay. Did you see the vehicle stay on the north side of the road for the duration of the time that you observed it?
Yes.
So you never saw it go to the other side of the road or?
No.
No further questions at this time.
Thank you. Any cross?
Yes, just briefly. Good afternoon, Mr. Hayes.
Good afternoon.
Thank you for your attendance, sir. Mr. Hayes, do you remember seeing a police officer at this intersection as well?
I don't recall.
Okay. Do you remember writing in your report or telling the police officer that a police officer chased the vehicle on foot?
Objection, leading.
Overruled. It's cross. You may answer.
I do remember that I thought I saw a police chasing after the car on foot.
Okay. And do you remember also telling the same officer that the SUV took off down the street and that it accelerated?
Yes.
Objection.
Is that
Hold on, there's been an objection.
I guess the objection to be what officer is being referred to wasn't clear.
Overruled. The state may continue asking the question.
The
I
objection
guess I was
would be
asking,
made.
was that referring to the interview officer?
Your
Vague.
objection is noted. It's overruled.
Objection
The
is
state
made.
may ask the question fully.
Is that your recollection, sir, that the vehicle sped off and accelerated away?
Yes.
Objection speculative.
Overruled.
Do you also recall telling the officer who interviewed you that the driver of the vehicle had a dark complexion and a beard?
Yes.
Is that accurate with your recollection of the driver?
Yes.
But you didn't see a face, you couldn't
No.
identify anybody
leading.
beyond those descriptions,
They
correct?
lead on cross.
There's been an objection to leading. It's overruled. The witness may answer.
No.
All right, thank you, sir. Those were all my questions.
Thank you. Any redirects, sir?
Briefly, very briefly.
The defense may call its next witness, please.
What just happened? What just happened?
Correct, yes.
Quick question before I do: who's supposed to be arriving at 3:30? Just so I know.
I'm not sure.
Didn't he say he had recross? Or redirect, I mean? And there were no questions, and then they...
No further questions at this time.
Thank you. Any cross?
Yes, just briefly.
Quick question before I do: who's supposed to be arriving at 3:30? Just so I know.
I'm not sure.
Badietz and Urel will be here at 3:30, Mr. Lister. That the SUV took off down the street and that it accelerated.
Yes.
Objection.
I'm glad you found me,
There's
Ken.
been an
I
objection.
don't get a hold of you.
Referred to.
This is the first witness back. We just started back. Because they, all they had left in the other trial for today was the charging conference. And everybody decided they wanted to go back to Brooks. So we went back to Brooks. Do you think Sue Opper crossed him because she needed to, or because she didn't want Darrell to have another conniption over not crossing the witness? I think that's what I thought at first, but no, I think she really did want to, because he did have pertinent information. Oh, okay. Okay. So it wasn't me. It was the trial. All right. I thought it was me. I thought I messed something up. Because he said he was going to ask questions, and then there were no questions.
What were you doing that evening, if you recall?
The Christmas parade.
Were you on this question? What were you doing that evening, if you recall?
Good afternoon, sir. If you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand. And my clerk Teresa, who will be across from you or is across from you, will swear you in. Thank you.
You know how they say when people are like fatally like on their deathbed, like when they're about to die, how they can like see stuff? Are dogs like that too? Like, serious question. Because Belle barks at nothing all the time now. Like, she'll look like she's looking at something. It's like she sees something. And like, it's the intruder bark. It's not like a feed me or I have to go outside or a play with me bark. It's like, okay, well, this is a new thing. That's why I asked, because I'm wondering what she's seeing, because she didn't used to do this. She does it all the time now. And I thought maybe she's seeing like the other side or something, and I don't want her to see it yet.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat. First thing I will have you do is to state your first and last names for the record and spell each.
Abel Lascano, ABEL-LAZCANO.
Thank you. Your witness, sir.
Good afternoon, Mr. Lascano. What do you do for a living currently?
I'm a hairdresser.
He's a hairdresser?
No judgment whatsoever on this question. Have you ever been convicted of a crime?
Yes, I have.
And how many times?
7.
Do you recall the night of November 21st, 2021 pretty well? I know it's been a minute, but
Best as I can, yeah.
what were you doing that evening, if you recall?
The Christmas parade?
Were you marching in the parade? Or?
No, I was watching it.
Uh, who were you there with? Family, friends?
My wife and my daughter.
Do you recall where you
Judy, I'm
were
sorry.
positioned to watch the parade?
I was standing in front of the.
I'm not, guys. Just came out the airport.
Is that part of Main Street close to like a side street? If you recall,
Not too far from Maple.
do you recall the side streets being barricaded during the parade?
Yeah, I don't remember.
Do you recall what time you arrived at the parade that evening?
It had just started, so whatever time that was at.
Okay. You recall something other than the parade catching your attention that day?
People getting hurt, yeah.
And what did you see that day, if you recall?
I saw a red SUV plow over a bunch of people.
And did you see the driver of this SUV you're referring to?
Yeah, you're standing right there.
And how many people did you see in the vehicle?
Just one, the driver.
So, do you recall flagging down a law enforcement vehicle that evening?
Yeah, I do.
And do you recall what you told the officer that evening?
Not very well.
I'm gonna attempt to see if anything brings back some recollection. First, do you recall the name of the officer you flagged down that evening?
Officer Moss.
Do you recall telling Officer Moss that you observed 3 or 4 people in the SUV as it passed you?
I don't remember that.
So, to your recollection, the SUV that you saw, did it have tinted windows?
I don't remember.
And do you remember what the description was that evening that you gave to law enforcement?
I told him it was a red SUV.
The description of the driver, do you remember that?
Yeah, I know he was a black male.
Is that all you recall about your description?
That's all I remember.
After seeing this vehicle, what did you do?
We left. I got my family out of there.
And where did you go?
We headed back to the car.
Do you recall where your vehicle was parked?
I believe it's the Lindholm or building. On Maple Street.
And did you see the vehicle stop on Maple Street?
Which vehicle?
The SUV that you claim you saw.
Oh, no, I didn't see it stop, no. It kept going through the parade.
And speaking with, is it Detective Moss? Well, speaking with law enforcement that evening, do you recall advising law enforcement that you observed 3 black subjects running from the vehicle?
No, I don't remember that.
If it pleases the court, I would like to show the witness this. I'm referring to page 4 exactly.
Every time he does something like
Is
that,
a statement this witness personally wrote?
like
I believe
he does
it's
something
with,
like
I don't think he wrote it himself.
So it's a summary written by another person.
By I don't know if it's Officer Moss or Detective Moss. I'm not sure if
Yeah, we
what his
watched
rank
the
is.
for what?
Continue with your questions. I'm going to deny the request that you show the exhibit or the paperwork to the witness.
Do you recall making the statements to Detective Moss that you observed one where it says 1 was described as running southbound on Maple towards College Avenue? Do you recall that?
No, I don't.
Do you recall stating that the other 2 were described as running in a westerly direction from the rear of 338 Maple Street?
No.
Do you recall stating that 1 black subject was described as tall, wearing a blue top and blue and black pants, while the other subjects were described as 2 short black males wearing sweatpants?
Barely, a little bit of that.
So, which of these subjects do you minimally recall wearing those items that evening?
No, you asked me if I remember people running, and I said no. I remember describing those people to him. I remember.
So where did you observe those?
Standing by the vehicle, where I found the vehicle, where I spotted it.
Just so we have clarity, describe the subjects you saw that evening standing by the vehicle.
I don't remember that good. I mean, you were describing them, so it brought back a little bit, but I can't tell you. That was too long ago.
And how did you come upon the vehicle at the address of 338 Maple Street that evening?
I was walking my family back to the car. Trying to get them to safety. So I was keeping an eye out and I spotted it.
Do you recall stating that you saw the SUV reverse into a driveway?
No.
Do you recall why that would be reported?
No. When I found it, it was parked already.
Gosh, Spike, don't growl at her. Didn't do nothing to you. Shut.
Do you recall when you initially had the interaction with Detective Moss? Do you recall him to where the vehicle was ultimately found? Do you recall yelling at subjects standing outside of a building where, or near where the vehicle was that evening?
I remember asking them. I don't remember yelling at them.
None of these questions help him. He's just reading off the police report. It's so stupid.
Do you recall why? Do you recall why the report says that you advised Detective Moss that there are 3 black subjects, specifically black subjects, running from the vehicle?
No, I don't remember.
Were you yourself injured in this incident that evening?
No.
Do you recall stating that, well, let me back up for a minute. Did you speak with another detective that evening, if you recall?
Yes, I did.
And do you recall if that was Detective Coates?
I don't remember his name.
So it'd be fair to say that you spoke with 2 different law enforcement officers that evening.
Yeah.
Do you recall in your interview with Detective Coates, in reference to the vehicle that you saw that evening, do you recall telling Detective Coates that it appeared there were 3 or 4 people in the Ford Escape as it passed you?
No, I don't remember that.
Do you recall in your interview with Detective Coates that evening, stating that you could not provide any description of the occupants other than that they appeared to be African American.
Yeah, I remember saying that.
So it'd be fair to say that you observed African Americans in this vehicle that you saw, correct?
The reason why I came up with 3 or 4 people was because when I was walking by and I saw the car, there was 2 or 3 black males standing by the vehicle, and there was at least 3 or 4 more on the porch. So I figured they were by the vehicle. It must have been the ones trying to hide the vehicle because they were standing in front of it or real close to it.
In your opinion, did it look like they were nervous or attempting to hide?
Well, everybody was running past them and walking really fast, and they were just standing around there. They were the only ones not doing much. So yeah, they stood out.
Now, this is the question actually was in reference to when you spoke with Detective Coates that evening, and is in reference to seeing the vehicle in the parade as it passed you. Do you recall at that point, while at the parade that evening, do you recall stating to Detective Coates that it appeared that there were 3 or 4 people in the Ford Escape as it passed you during the parade that evening?
No, I don't remember that.
Any reason why the Detective Coates would report that that's what you stated to him?
Like I said before, I saw 2 or 3 people by the vehicle, so I assumed they were with the vehicle. So they must have been in the vehicle during the parade. I saw the driver going by because he hit somebody right in front of us.
Do you recall in your interview with Detective Coates that evening stating that the 3 individuals, and I'm referring to who you saw next to the vehicle, so it's clarification. The 3 individuals who were standing in a line, shoulder to shoulder, as African American males?
Yeah,
So it's fair to say that's what you observed that evening?
I saw at least 2 of them. And looked like they were standing in front of it.
And during that interview with Detective Coates that evening, do you recall stating to Detective Coates that you may be able to recognize the older male? So I'm assuming one of the individuals that you saw standing shoulder to shoulder was a older male?
Yeah, I don't remember.
Any reason why I'm not gonna say multiple, 2. Any reason why the 2 detectives that you spoke with that night both reported that you stated you saw 3 black subjects running from the vehicle?
No.
And during the parade incident, were you or anyone you were with injured that evening?
No.
No further questions at this time.
Thank you. Any cross?
Yes, Your Honor, thank you. Good afternoon, Mr. Lascano.
Good afternoon.
Sir, you said you watched the parade near Curry Insurance, is that correct?
Yeah, right in front.
Okay. Do you remember, you said you saw the SUV strike some people in the parade?
Yeah.
Yes? Do you remember what group of people in the parade? Can you remember anything about the name or the banner or the costumes or anything like that?
Objection leading.
Overruled. Ms. Cross.
No, I don't.
Speculative. Objection.
Overruled. The witness may answer. I believe he said no. His answer may
Yeah, no, I don't remember.
Okay. Do you remember seeing the SUV strike more than one person?
Yeah.
Objection. Speculative.
Overruled.
About how many people did you see the SUV strike, sir?
Objection. Speculative.
Overruled.
It was crowds. I mean, when it was coming through, because I was standing over my daughter and my wife, they were sitting on the curb. I saw it coming through, and at first it looked like it was just pushing people out of the way, and then it just kept swerving back, and it was just plowing everybody out of the way until it got to in front of us. Then it actually hit somebody, and it just did like a cartwheel in the air.
You remember that?
Yeah, it was right in front of us.
Okay.
And while the witness was giving the answer, not the last answer, but the one prior to that, he had his right hand in the air, directioning his hand from right to left, describing the vehicle coming from right to left. And then when he said he saw someone go into the air, he was twirling his fingers as if to say it kind of tumbled in the air. All right, go ahead.
Thank you. So, Mr. Lascano, I want to talk about the moment when you located this vehicle on Maple, okay? I'm going to ask, Madam Clerk, could you please turn on the AV system? We're going to put up State's Exhibit 65.
Go ahead.
Objection to the relevancy of Exhibit 65.
Noted, overruled. It's been received. The state may proceed.
All right, this total clip is 36 seconds, but before we begin to play it, sir, do you recognize the area on the screen that's
Yeah.
shown in this picture?
Yeah, I believe that's Central Middle School,
Where?
right at where the stairs is.
Okay, the red brick on the left side of the picture?
Yeah.
Objection.
Okay.
Speculative.
Overruled. His answer may stand, he said, I believe.
And would you agree with me, the house where the SUV was found was up in this area here where I just put the green dot on the screen?
Yeah.
Objection leading.
Overruled. You may answer.
Yes.
That looks right, correct, sir?
Objection leading.
Overruled.
All right, we're gonna clear the screen, please, and we're gonna play this entire clip for 36 seconds. Please watch and see if you see yourself or any of your family members in this clip.
Objection to the relevancy of this video to this particular witness.
Overruled. You may play the clip.
Overruled on what grounds, Your Honor?
Because she said so. There's your ground. She said so.
Is that attacking agreement?
Since it's worded.
Sir, did you see yourself or your family in that clip?
Objection. Speculative.
Overruled.
No, I did not.
Okay. Now, you said you did see, by the time you walked past the car, you saw 2 or 3 black males standing near the car, right?
Objection. Mischaracterization of this. He said 3. Specifically said the number.
Overruled.
That's a new objection. You almost
And you
can't
also
say
said
that
you
word.
saw 2 or 3 what you thought to be black males on the porch of the residence there, correct?
Objection. Stated it was black males. Asked and answered.
Overruled. The witness may answer.
No.
I'm sorry, go ahead.
No, there was 2 or 3 standing by the vehicle,
Okay,
and then on the porch there was maybe 3 or 4 or more people. I don't know if they were. I'm sure they were white, but
Okay.
I was trying to not make it obvious because at the time, I believed that they were with the vehicle, so I didn't want them to see that I saw them. So I just did what I
Understood.
thought was right at the time.
Sure. Do you happen to know the people that live at this house?
Objection speculative.
Overruled.
No, I didn't.
Would it be reasonable, do you think, Mr. Lescano, that people living in the house heard the crash and came outside and that's who you saw standing there by the vehicle?
Objection. There was never any crash mentioned.
That
I'll sustain. Calls for speculation.
was speculation, yeah.
Mr. Lescano, is it possible that the people you saw standing near the vehicle were in fact just neighbors that saw the vehicle the same way you did?
Yeah.
You described that at the time you went by on Maple Street, there was a lot of people running around in the area. Is that correct?
Objection. Mischaracterization of testimony.
Overruled.
Yes, it was.
And these are people hurrying away from the parade with their families, trying to get to safety just like you were, correct?
Objection speculative.
Overruled. The witness may answer.
Yes.
You didn't see anything like that in State's Exhibit 65, did you?
No, I did not.
Okay. You said on direct examination that you saw the driver of the SUV in the parade, is that right?
Yes, I did.
And you see that driver present in this courtroom here today, please?
Objection speculative.
Overruled.
When he
Yes,
gets
it's
upset,
sitting
he
over there.
starts
Are you sure
like
about
a
this,
baby.
sir?
Yes.
Objection speculative.
Overruled.
You
And
said
it
that.
mischaracterizes the testimony because that was not testified to before on direct.
Oh, your objections are overruled. I believe the witness already answered. Go ahead.
Did you happen to notice in Exhibit 65 the red SUV in that video clip that you watched?
No.
You didn't see it at
Couldn't
all,
see
did
it,
you?
no.
Okay, just wondered. Mr. Lescano, have you and I ever spoken about this case, sir?
No.
What about Attorney Basie here to my right? You and her ever talk about this case? Your testimony?
Objection hearsay.
Overruled.
No.
Mr. Witchow on the end, did you ever talk to him about
Objection.
your testimony, sir?
Objection hearsay.
Overruled.
No.
All right, thank you, sir. I don't have any other questions.
Thank you. Any redirect?
Yep.
Go ahead.
Yep. So rude. So rude.
You stated that you saw the driver, correct? Of the
Yeah.
SUV that you saw that day, correct?
Yes.
And how did the driver look that day you saw him?
He had a scruffy beard, and he was a black male.
Did you see what the driver was wearing?
No, I don't remember that.
Did you see if the driver had any hair?
I don't remember that either.
Did you see if the driver had anything noticeable about their appearance? Tattoos, scars, marks, anything like that?
No. I saw the side, the profile, the side. You were flying fast down that street.
But you.
I wasn't paying attention to the color of clothes you were wearing. I knew it was a black male and had a scruffy beard. It's the first thing I told my wife, is he was a black guy driving.
And you, dude. And you.
And do you recall how long you were able to get a side view, as you called it, of the alleged driver?
No, I had to be a couple seconds.
And in a couple seconds time, you were able to make out the driver's profile and race just by a couple seconds.
Yeah. It's not hard. can tell if you were white or if you were black and if you had a beard. No, that's it. I don't know what color shirt you had on, if you had hair, a hat on backwards.
So that leads back to the question of, is that the only person you saw in the vehicle?
From what I remember, yes. I saw the driver. Like I said before, the reason why I thought there was 3 or 4 because I saw 3 or 4 people around the vehicle when I spotted it.
So would it be
That's the only reason.
Would it be fair to say that when you spoke with 2 different detectives that evening, the evening of the parade, both of those officers reported that you stated there were 3 or 4 people in the SUV as it passed you? Is that fair to say?
Oh, wait, can you repeat that again?
Just for clarification, you already stated previously in testimony that you spoke with 2 different detectives that evening, correct?
Yes, I did.
And both detectives that you spoke with that evening, the evening of November 21st, 2021, you stated to both of those law enforcement officers, detectives, that you observed 3 or 4 people in the SUV.
Like I said before, the reason why I said there must have been 3 or 4 was because they were standing by a vehicle. So I assumed that they were with the vehicle. I don't remember seeing them in the vehicle when you were hitting the people.
You stated this to both detectives, 2 different detectives, the evening of November 21st, 2021. And this was in relation to what you saw from the vehicle at the parade, not where the vehicle was later found. Any reason why you stated to both detectives in relation to what you saw at the parade, why both detectives in their reports stated that you told them that you observed 3 or 4 people in the SUV at the time of the parade?
So what's your question?
The question is, why did you report that to 2 different detectives on the same evening?
Like I told you before, when I walked past the vehicle, I spotted more than one individual standing in front of the vehicle. So I assumed they were with the vehicle. That's why I said they were inside.
I'm sorry.
That's why I said they were in the vehicle. I said there had to be at least 3 of them in the vehicle. That's the only reason I said that.
Why would you report that you saw this during the parade?
I don't know.
He was wrong, Darrell, okay? He made a mistake. He's human.
And during
That doesn't
both
get you off the hook.
interviews with detectives that evening, the evening of November 21st, 2021, you also stated to both detectives that you observed 3 or 4 black or African American is the word used. 3 or 4 African Americans running from the vehicle. Any reason why both detectives reported that you said that?
No, I don't remember.
No further questions.
Thank you, sir. You may step down. Do we have additional witnesses here?
Yes, Your Honor, they're right.
All right, would that be how many people?
There's 2 left.
Okay. So the 2 left on your list, your next witness, sir.
So I'm guessing that's, oh, I know who it is. Just give me 1 quick second, Your Honor, 1 quick second.
Go ahead.
Oh, you missed it, Wiggles. He got in trouble.
Sorry about that, Your Honor. I'm just
Finished.
making sure I have
His
the
cross
correct
or
paperwork.
is correct on her.
My jurors need to stand. Go ahead.
This is what I was looking for. So much paperwork.
Or not yesterday. Wednesday, Friday.
Okay. Great. If she can print it, that'd be great.
Yeah, we haven't got to the box for it yet. Still got that to look forward to.
Okay, I'm ready, Your Honor.
Go ahead. Call your next witness.
Kathleen Urel?
Urel? That's how I think it is. We'll find out.
Didn't he question a mom whose kids got hurt? I really move on his part.
All right, ma'am, if you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and my clerk Teresa, who's on my left, will swear you in. Go ahead and come all the way up. Thank you.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please have a seat. First thing I will ask you to do is to state your first and last names for the record, and then spell each.
Kathleen, K-A-T-H-L-E-E-N. Last name Urel, Y-O-U-R-E-L-L.
Thank you so much. Your witness, go ahead.
Good afternoon, Miss Urel. Is it Urel?
Urel.
Urel. What do you do for a living?
I'm in workforce management for a call center.
November 21st,
One of
2021.
those things.
Directing your attention there. You recall that evening pretty well?
Just ask her.
Off and on, sir.
That's fair. It has been a while. Do you recall what you were doing that evening?
Yes, sir.
And what were you doing that evening?
At what time?
Around 3:30, 4 o'clock-ish.
I was dropping off my children who were participating in the parade.
And did you yourself stay for the parade?
Partial parade, yes.
Partial meaning maybe a few minutes.
Until my group of children went by.
Okay. Do you recall where you were positioned during watching your group participate in the parade?
Yes, on north and east, right on the corner there.
North and east.
If you're going parade route, it would be on the right-hand side.
Okay. Just so we have clarification, can we pull up the exhibit? I believe it's 15.
We can.
Thank you.
Go ahead. Thank you.
Kids.
And we show it to the witness first.
He doesn't want it published, so just to the witness for now.
Just not yet. Just I'm going to make sure the witness gets a chance to view it first. Can you see that on your screen yet?
I do.
And using the touch screen, it's a touch screen. Can you point out where
It's
you?
not published, so do you want it published?
I'm sorry. Yeah, publish.
Sorry, I didn't mean to interrupt, but I just wanted to point that
So
out.
just so I know, to use the touch, it has to be published.
No, she could use it, but if you're gonna have her do it, it should be done in front of the
Okay.
jury.
Fair.
Okay, go ahead.
I think we got to wait on the jury, right?
Thank you.
For the jury, can you, using the touch screen on your screen, can you point out exactly where you were positioned?
When I was watching it,
Yes, when you were watching it.
right on the corner, sorry. Oh, well, if you want to
Can you clear,
reverse it
can you
again,
clear
I'll do it
the
again.
arrow?
We'll clear it, you can do it again.
Yeah.
If you don't want, do you want the arrow?
Well, it was to the.
Clear it again.
Okay.
So it's a touch screen, so use your index finger and you can draw a circle.
Okay.
I was going to say that.
Well, I mean, it was right there, but.
I was going to say a circle or a little dot if.
Well, I thought I was doing that, but.
Yeah.
Oh.
Hold on.
Heavy
We'll do it
hands.
again. So press and hold while you draw.
Okay.
There you go.
And you said that would be approximately East Main and Northeast?
Correct.
And do you recall if those, well, there's side streets right there that you can see, is that fair to say?
Correct.
And those side streets would be Northeast and Buckley, correct?
Correct.
Do you recall if there were barricades at those?
I can't honestly recall. I can't be sure.
We can take Exhibit 15 down.
Thank you. Go ahead.
And you said you stayed at the parade until your group had passed.
Correct.
And what time did you leave?
I can't determine the time. It was right after my group of kids went by.
And where'd you go from here?
I walked down, well, I went to go get the car because I had to go pick them up at the end of the parade.
And I'm assuming at some point your attention got drawn to something happening. That'd be fair to say?
Not necessarily.
What do you remember when you went to go get the vehicle to pick up members of your group? Would that be fair to say first? I don't want to assume.
Yeah.
Do you recall anything happening at that point?
A situation did occur before the said big event that took place.
What do you recall happening at that time once you were on your way to get your vehicle?
I think I need more specifics from you to give the details you may be looking for.
While you were getting your vehicle, did you observe anything happening? Did you overhear about anything happening at that point?
Nothing of that nature. Well, all I can say is that I was walking past White Rock.
Did you see anything that may have alerted your attention at that time?
Yes, a car coming through the parade at the beginning on White Rock where the parade was starting. So when I left, I walked down Main to White Rock on the corner there. Then a gentleman, a child who I don't know who they were, and myself walked across the street. And at this time, a car was beeping and weaving around a slight curve that White Rock has, and then continued on.
Did you see did you see where the car went at that point?
Yes, I did. As it came around the slight curve White Rock has, it started to move forward, and then it went straight across. When I was thinking it was going to leave the parade route, if you leave the parade route on Main, you're leaving. Sorry, if you turn left, you're leaving the parade route. If you're turning right, you're going right into the parade, and it went right to the, if you're looking at the parade, it was on the right-hand side, and it's continued on into the parade.
Hold on, just for the record, she was using her hands during her testimony. I just need, that's okay. I just need to make a record of it. Usually her right hand just kind of demonstrating the course of travel that she described, the vehicle. And I think that's probably all I need to put on the record. Sure. Go ahead. Next question.
I want to back up a little bit. When you first observed this car, as you say, you recall that it was blowing its horn.
Yep, it was, the horn was beeping.
Do you recall if you saw who was operating that vehicle?
Unfortunately, sir, I can't recall.
Do you recall if you might have seen multiple people in the vehicle at that time? Or?
You know, unfortunately, due to the time passing, I cannot recall.
That's fair. It has been a while. Do you recall about what time that was that you observed the vehicle?
Again, I can't be sure.
Sorry if I keep asking.
No, I can't be sure. I'm sorry.
At the time that you observed the vehicle, did you see it strike anyone?
I did not. Or at least I don't recall. I'm sorry.
And do you recall if the vehicle was speeding at that point that you observed it?
It wasn't speeding, but it was, all I can state is it wasn't speeding.
Did you happen to catch the license plate number of the vehicle at that time?
No, not at all.
Do you recall if the vehicle had any tinted windows?
I couldn't recall. I'm sorry.
Any windows rolled down or up at the time you observed it?
No, unfortunately, I don't remember.
Do you recall if the vehicle passed close to where you were walking at the time?
Yeah, it was close enough that it could have easily have clipped me or the two people that were in front of me.
Where you were, the two people that you referred to in front of you, were any of you hurt at that time?
No.
No further questions right now.
Hey, Cross.
Yes, thank you. Good afternoon, Mr. Rell. Thank you for being here. You testified on direct examination that you don't recall whether or not you saw more than one person in that vehicle we're talking about. Remember saying that?
Yes.
You remember meeting on December 2nd, 2021 for an interview with Detective Jay Carpenter from the Waukesha Police Department?
I remember going as to a lot of topic of conversations. I unfortunately can't recall those too clearly.
Do you remember telling Detective Carpenter that you only observed a driver in the vehicle?
Objection, leading witness.
Yeah,
Overruled, you may answer.
I can't be too sure.
Overruled, you may answer.
Can you say that again? I'm sorry.
I can't be too sure. Again, some of the conversations I might have had that day.
Do you remember what this vehicle looked like?
I do not.
Do you remember telling Detective Carpenter that it was a red truck?
I do not.
Okay. Can we please put up for everybody Exhibit 15 again?
Go ahead.
Can we zoom in on the intersection of East and Main?
Go ahead.
All right, thank you. Your testimony is that you were standing here on the northeast corner of Buckley and Main Street, is that right?
Correct.
Objection, already answered that, asked and answered.
Overruled, you may answer.
You said correct.
Correct.
And after your children walked by in the parade, you walked in this direction towards the intersection of White Rock and Main, is that correct?
Objection,
Correct.
leading and speculative.
So overruled as to both, you may answer. If there is another objection, just
I'll
wait
pause.
until I rule out.
Sorry.
Thank you. No, that's okay.
Correct, that was.
And then you crossed through the crosswalk on the north side of Main Street, is that correct?
Yes.
Is that when you saw this vehicle we've been talking about?
Yes.
So you were standing in the crosswalk.
Correct.
Do you remember a police officer being in that intersection?
I can't be too sure.
Okay. Was it clear to you that this was a parade route?
Yes, it was very clear.
Was it clear to you that traffic from White Rock should not have driven onto Main Street
Yes.
unless they were part of the parade?
Yes.
Did it appear to you as though the vehicle we've been talking about was part of the parade?
No.
How many children do you have, Miss Urel?
Objection, irrelevant.
Overruled. You may answer.
4 children.
All 4 of your kids were marching in the parade that day, weren't they?
Yes.
Objection, leading.
Overruled.
Sorry.
Your oldest daughter, Charlotte, she was 14 at the time?
Yes.
She was marching with the Extreme Dance Group as an alumni, wasn't she?
She was handing out candy.
Objection.
There was an objection. It's overruled.
I didn't even state why I was objecting, but okay. We still need a 15.
Yes, please. You see on that map the 5 points intersection?
Yes.
When you were standing in the crosswalk at White Rock in Maine, could you see the 5 points intersection?
I could not.
You didn't see your kids get hit, did you?
I did not.
Objection, leading.
Sorry.
Overruled.
Again, sorry.
Objection, hearsay.
Overruled.
You didn't.
I did not.
Did you see them later that night?
Objection, leading.
Overruled. You may answer.
I was only able to see 2 of my children that night.
When did you see the other 2?
days later when I was able to leave Children's Hospital.
As their mother, you were directly involved in their medical care and the decisions that were made in that process in the days after the parade?
Objection, leading.
Yes, their father and
Charlotte suffered a chipped vertebrae from being struck, didn't she?
I. She did.
Objection, leading.
Overruled.
She did.
Your daughter Alice, she was 10 at the time, wasn't she?
She was.
She suffered chipped front teeth, is that correct?
Yes.
And facial scarring
Yes.
and road rash
Yes.
and a broken fibula and tibia
Yes.
and broken metatarsal bones.
Yes.
She was observed in a concussion protocol, is that correct?
She was.
Your daughter Vivian, she was marching with the extreme dance group too, wasn't she?
Yes, she was.
How old was she in November of 21?
She just turned 7.
Vivian suffered a severe concussion, didn't she?
Objection, leading.
Overruled. You may answer.
Yes.
And road rash
Extreme road rash.
and a lung contusion
Yes.
and facial scarring.
Yes.
And your 7-year-old daughter Vivian suffered a broken tailbone, didn't she?
She did.
Your son Grayson, he was 8 on November 21st, 2021, is that correct?
That is
Objection,
correct.
leading.
Overruled.
He was walking with the extreme dance group handing out candy, is that right?
He was.
He went to the hospital after the parade, didn't he?
Yes.
He suffered a compound fracture in his femur, is that correct?
An open compound fracture.
Meaning the bone came through the skin?
Yes.
Objection, hearsay. I don't believe he's a doctor.
Overruled. The witness may answer based upon personal knowledge.
Was that a yes?
Yes.
A police officer saved Grayson's life by placing a tourniquet on that open leg wound, is that correct?
Yes.
I don't have any other questions.
Will you read the record?
No redirect.
Do it. Thank God.
You may sit down.
He did something smart for once.
You may call your next witness, please.
So we gonna take down these exhibitors, you gonna stay up on
Oh,
there?
thank you. We'll take it down.
Yeah. Good job, Zach. Good job.
Please call your next witness.
Just 1 second.
Sales.
So only one more person here, right?
It's my understanding, sir. that be correct, Attorney
Yes.
Hopper?
Yes, she's in the courtroom, ready to go, Your Honor.
I don't think he pre-read any of the reports. I think he's just standing up and reading them right then and asking questions. Because none of it's helping his case. None of it. He's just picking people that talk to detectives.
Defense calls Catrice. I don't know how to say the last name.
Can you give me the spelling that you have?
Babias.
And it's Babias? What's your last name?
Babias.
Babias. All right. Thank you. You are at the witness stand. Would you please raise your right hand? My clerk Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes, thank you.
Thank you, ma'am. Please have a seat. First thing I will ask you to do is to state your first and last names for the record, and then spell each.
Catrice Babias, Katrice Babiaz.
Thank you. My apologies for mispronouncing that earlier. Go ahead.
Good afternoon, Miss Babias.
Correct.
I'm surprised I got it right.
I'm a law enforcement dispatch supervisor.
And how long have you been doing that now?
I've been in law enforcement for 16 years.
The evening of November 21st, 2021, were you on duty that evening?
I was not.
What were you doing that evening?
I was attending the Waukesha Christmas parade with my family.
And do you recall what time you arrived there with your family that evening?
I arrived to the parade shortly after it started, so it was right after 4 p.m.
And do you recall where you were positioned at with your family when you arrived at the parade that evening?
Yes.
And where were you positioned at?
I was towards the beginning of the parade. I was on Main Street where it connects with White Rock Avenue.
Did anything catch your eye that evening when you were positioned watching the parade with your family?
Yes.
What did you see?
I saw a red SUV coming from White Rock Avenue. The vehicle caught my attention because people started yelling, and the driver was honking the horn.
And do you recall, to the best of your knowledge, it's been a little bit, the driver of the vehicle you observed was honking his horn? Was it gesturing to people?
Yes.
And what do you see? What did you see the gesturing as?
I'm sorry, I don't understand the question.
What was the gesturing?
What was the driver gesturing?
Yes. I'm sorry.
It's okay. So he was taking his hand and going like this, really rapidly, aggressively.
So for the record, the witness had her right hand up above, probably above her, I wouldn't say at a 90-degree angle, but somewhere maybe at a 45-degree angle with her hand waving back and forth multiple times in a rapid motion. Go ahead.
You yourself being in law enforcement and just based on what you were observing, the driver of the vehicle you observed was honking his horn and gesturing with this motion. Would you take that motion as trying to alert people to move out of the way? Grounds.
Sustained is to the form of the question. Please rephrase.
How did you yourself take that gesturing?
I took that gesturing as the driver was telling people to get out of his way.
Do you back up? Did the vehicle pass pretty close to where you were positioned?
Yes, the vehicle almost struck my daughter.
Do you recall seeing the driver?
I looked the driver right in the eyes.
And how did
Thank you.
What do you mean through you? Describe what you mean by through you.
I feel that it is very hard to explain that look, but it was very frightening.
Do you recall what the driver was wearing?
The driver had a hoodie sweatshirt or sweatshirt on, and something on his head. I wasn't sure if it was the hood of the sweater or maybe a beanie hat. It was winter. I'm not 100% sure.
Were you able to see any hair?
I did see hair, yes.
How would you describe the hair?
The hair on the head was in front, like dreads down here from what I could see underneath the hood or the hat. And then there was facial hair, beard and mustache.
Did the vehicle...
Hold on, I just need to make a record of, she was also using her hands, that's okay, to indicate at the neck, like under the neck area, with her hands coming down a few inches to indicate what she was hair being seen from the driver. Thank you. Go ahead, sir.
When you observed the vehicle approaching, was the vehicle speeding?
When the vehicle was approaching from White Rock, the vehicle was not speeding at that time.
To the best of your knowledge, do you recall there being any barriers present where you were positioned at?
Yes.
Do you recall if the vehicle you observed had any tinted windows?
I do not recall.
Were you able to make out a license plate number of the vehicle, being that it had passed so closely by you?
No, once the vehicle continued past my position, I was more concerned about my children that were with me.
I'm assuming at some point you spoke with the law enforcement about what you saw that evening. Would that be fair to say?
Yes.
And do you recall what agency that was?
I do.
And what agency was that?
The FBI.
At what point were you not able to see the SUV once it passed you?
I lost sight of the SUV once it went into a bunch of people.
Do you recall what date it was that you spoke with the FBI agents on? Was that the same evening or a few days after?
It was not the same evening of the parade, but it was that week. It was within the next few days.
The day you spoke with FBI agents, do you recall stating the driver was wearing a red top that appeared to be made out of a sweatshirt-like material?
I don't recall exactly what was said to the agent, but I do remember the sweatshirt, yes.
A red sweatshirt?
It's possible.
Just a little bit ago, you said that, well, when asked the question of did you recall hair for the driver, you stated and made the gesture that the hair was in front. Do you recall saying that?
Yes, sir.
Do you recall when speaking with FBI agents stating that the hair was pulled back?
The hair appeared to be like possibly in a ponytail, but it was so full that it was coming forward.
Have the questions ready. If he had read it already, he'd have questions ready. There wasn't this big dead air.
Do you recall?
He's not read these reports already.
Well, let me back up. Did you leave the parade at that point?
At what point?
After seeing the vehicle.
Yes.
Were you injured the evening of the incident?
Yes.
You were injured?
Yes, I was.
Any reason why that's not reported?
Probably because they didn't tell anyone else.
If you were injured, why not tell anyone?
Because I haven't wanted to talk about the traumatic experience that I went through for still reliving the weeks and days after the incident.
It doesn't make any sense. You talked to FBI agents a few days where you said you didn't to be fair, you said you didn't know. You said it was that week, is what you said. The same week. You spoke with FBI agents.
Don't belittle her
Reported
pain.
no injuries.
Caused.
They didn't ask me about injuries.
Well, would it be fair to say that kind of information would come up when talking to law enforcement, seeing as how you yourself work in law enforcement? It just seems odd, don't you think?
I do not. I was not physically injured.
Oh.
What was that O for? And swipe? Sorry, Judy. Don't belittle her pain. You probably scared the
But you didn't report this at any time whatsoever. Grounds.
Sustained. Already answered.
So did you speak to anyone about this in law enforcement?
Objection made.
Grounds.
Overruled. She may answer. He clarified law enforcement. Did she speak to anyone about this in law enforcement? I interpreted this as the injury.
Right.
So go ahead.
I feel like, no, I did not.
Did you file any claims related to the incident?
No, I did not.
So is today your first time bringing up your alleged injury?
No, it is not.
At some point, you were subpoenaed by the district attorney's office to testify here to testify in this trial. Would that be fair to say?
Yes, it is.
Do you recall when you received that subpoena?
From the district attorney's office, it was in July.
And do you recall whom you spoke with about the information regarding the subpoena?
I contacted the victim witness advocate, Carrie Peterson.
You contacted the Ms. Peterson after receiving the subpoena?
Correct. The instructions told me to.
Okay. You ever spoke with anyone directly at the district attorney's office?
No. Correction. Yes, when I walked in today, I met there and let them know I was here, and then they walked me into a room, and I waited until I was called.
day you had no interactions with anyone related to the district attorney's office besides I think you said victim advocate?
So the victim advocates who have been in connection with and letting me know when to come and all of that.
Of the three district attorneys seated to my left at this table, had you had any interactions of any kind with any of those three district attorneys?
I have not.
And I believe, just for the record, when you asked that, Attorney Basie was just pointing to herself and the two people next to her, so it's clear, because since there's two tables.
What would be the reason for that?
Since there's two tables of individuals, I think she wanted to make the witness aware. And I just wanted to point it out for the record since it happened.
You are such a jack.
Working in law enforcement for 16 years, I'm sure this isn't your first time being involved in a trial. Would that be fair to say?
I have not been in a trial for law enforcement. No, I have not.
You've never witnessed a trial, sat at a trial, been in a trial?
I have not.
Have you ever testified in any way before today? Grounds.
Overruled, you may answer.
I have testified before, yes.
So it would be fair to say that you would have knowledge of where an alleged defendant and the district attorney would sit in the courtroom, correct?
I know where they're sitting, yes.
I want to back up a little bit to the observation of the vehicle the evening of November 21st, 2021. While you observed the vehicle approaching your position, did you see it strike anyone?
I did not see the vehicle strike anyone, no.
From your opinion, observing the vehicle approaching your position, did it appear that the vehicle attempted to strike anyone?
Yes,
And why would you come to that conclusion?
because I saw an officer have to jump out of the way in order for
When
the,
it was approaching,
when it was
question
a,
was when it was approaching.
I'm confused.
Hold on, everyone. The question was asked, this witness is going to be allowed to answer the question fully without interruption. Go ahead and answer the question.
Thank you. I misunderstood his question, I guess.
Answer the question that as you understood it.
Yep, so I saw that an officer have to get out of the way. And he was attempting to stop Mr. Brooks from driving through the parade, and he was at the last minute jumped out of the way from the vehicle, otherwise he would have been struck.
You just used the name Mr. Brooks for the first time that you've been testifying. Would that be fair to say?
I don't understand your question.
You just used the name Mr. Brooks for the first time since you've been testifying. Is that fair to say?
That's fair to say, yes.
Why haven't you used that name before? You've been up there for quite some time.
I didn't need to.
So what changed for the last question that you needed to?
I don't understand your question.
You just stated that you didn't mention the name before because you didn't need to. So what about the last question that you answered made you feel like you needed to use the name for that question and no question before that?
I don't know.
Look at Leslie's face. Pretty little man.
Out of curiosity, how did you come to the knowledge of that name?
It was on the subpoena I received last week.
You just stated a little bit earlier in your testimony that you received your subpoena in July. Now you said last week.
Those are both correct.
So you received two separate subpoenas?
Correct.
What was the difference between the two?
One was from the district attorney's office and one was from you.
So the one that you received from the district attorney's office in July didn't have a case caption on it?
Okay.
Just 1 second. 1 second, Your Honor. If I may
Just
have.
object to this line of questioning. I really don't know what the relevance is for the purposes of this trial.
There was no objection at first.
Well, there's a
There's no.
I'm going to sustain the objection under 906-11, because I don't believe it advances
I think
the trial.
I think you know where I was getting at with the question.
Then you need to ask your question directly, sir. Go ahead. But I'm sustaining it as to the form of the question.
When you were subpoenaed in July by the district attorney's office, the subpoena didn't contain information to the case you were being subpoenaed for?
Objection to relevance.
Grounds?
Sustained. You don't have to answer that. I sustained the objection on that. Those grounds. Ask the question I believe that you're trying to ask, not that one.
Was the name that you mentioned, Mr. Brooks, anywhere on the subpoena that you received from the district attorney's office in July?
Objection. Relevance.
Grounds?
Sustained.
Grounds for the sustained.
Not relevant.
What? Mind-boggling.
strike, move to strike, move to strike. Leslie, move to strike. Move to strike.
Sir, in July when you received your subpoena from the district attorney,
Objection. Relevance.
grounds?
Sustained. Not relevant.
She's testifying in the trial and it's not. What?
You called her as a witness. It's
The
your
subpoena that the subpoena is relevant because she
Mr.
was
Brooks,
already
under
subpoenaed.
906-11, please ask the witness a
This is
relevant and
mind-boggling.
probative question.
This is mind-boggling. Mind-boggling.
Remind the jury that the statements of the parties, the attorneys, are not evidence.
Gotta go through this field. So were you aware that it was a chance you would be possibly testifying in this trial?
Yes.
And did you know who the trial was for?
Objection.
Grounds.
Sustained.
Grounds for
relevant.
sustained.
But she said
It's not
so.
relevant.
I've never heard of nobody testifying in a trial that they didn't know who the trial was for.
Mr.
think
Brooks,
that's- I think
I'm
that's very
sustaining the
relevant.
objection under 90611, and I'm asking you to move on.
Y'all, this ridiculous, man.
You're ridiculous. Driving through parade was ridiculous.
Seems to me like a like a lot of your answers are coached. Is that fair to say?
No.
Are you gonna object? No? Leslie, what are you doing? Object!
So the subpoena that you got last week, is that how you learned the name that you used?
Objection.
Grounds.
Relevant to the same reason I argued before.
Grounds.
Asked and answered. She's indicated the answer already. 90611, sir. Next question.
The question
Different
was,
topic.
is that the first time that she saw the name?
It's not relevant.
That
Next
was not
question.
asked and answered. That was not asked nor answered.
Under 90611, please ask a
It's
question, sir.
irrelevant.
Man, what is y'all people trying to pull, man? This is ridiculous.
Mr. Brooks, if you don't ask another question that's relevant and probative under 90611, then I will turn the witness over to the state for their cross-examination.
And then I should be able to get redirect, right? Your Honor?
Ask a question, or I will declare the examination by you to be ended.
It's not an examination, it's direct.
It's a direct examination, sir. Under 90611, you are directed to ask a question, or I will ask the state if they have any
Your Honor.
questions.
I heard you.
Thank you. Next question, please.
You know who the plaintiff is in this matter?
Yes.
Who's the plaintiff?
The state of Wisconsin.
Is that an entity or a living human being?
Objection.
Grounds.
Relevant.
Not relevant, sustained. Next question.
Have you ever had any interaction with the plaintiff?
Objection. Vague.
Sustained.
Vague.
As to the form of the
Have
question,
you ever had any interaction with the state of Wisconsin?
do not answer that question. Next question, sir. Under 90611.
Was there an objection or was that just a rule? I'm not sure. You're both was talking at the same time.
Under 90611, I directed the witness not to answer that irrelevant question. Ask your next question, sir. Mr. Brooks, ask your next question.
I'm gonna get to it.
Thank you.
Don't think him he was rude to you. That, no. I'm a get to it. It was a rude response.
So when did you first report your alleged injury?
You do not have to answer that question. Next question, sir.
Grounds for
90611.
She said so.
Sub 1, Sub A, Sub B, and Sub C.
is that lawful law?
All right.
Yes.
You may sit down. Does the state have any questions for this witness?
Ma'am, that day on November 21st of last year, you were there with two kids?
I was, yes.
What were their ages on that date?
Objection.
3
relevancy.
and
Overruled, the witness may answer.
Of course it's going to be overruled.
3 and 6.
And I don't know, Mr. Brooks can sit down. I'm asking the questions right now.
Mr. Brooks, please sit down. Mr. Brooks, you're not asking the questions.
I'm not saying
I would
anything.
ask you to sit down, please. It is disrespectful to this witness and to the state and to the court.
No, it's not. Not doing anything wrong. I'm merely standing here.
And when you were at the parade on November 21st of last year, approximately where were you watching the parade from?
Asked and answered objection.
Mr. Brooks, it's cross-examination. Just because you asked the question initially and she answered does not mean the state doesn't get to follow up on it.
So the state can ask the same question I
The
asked.
state can ask their question.
So how
Go
come when
ahead.
I did that, it was
Overruled. The witness may
it was
answer.
insane.
I was on Main Street, but right by where the intersection of White Rock, and I was in the roadway.
I'm going to show you what's been marked and previously admitted into evidence as State's Exhibit 15.
Go ahead.
And I ask that the screen be cleared. And ma'am, does this show?
Wait till it's in the jury
Oh,
box.
sorry.
I'm sorry. The jury would let me know when it's there.
The jury's still there.
Thank you. It's there now. Go ahead.
Ma'am, do you see a purple line on that would indicate the parade route going from White Rock? Can you approximate where you and your kids were watching the parade?
Yes. Do you want?
If you have, sorry, it's a touch screen. I keep forgetting to say that. Touch screens, just put a dot right where it is. Okay.
Maybe on the other side of that red line?
So, okay, can we clear the screen and maybe just put a dot? I think that, or a circle. I think a circle would be good. Okay, thank you. Would be fair to say is to your left would have been Pleasant Street?
That is correct.
Were there barricades blocking Pleasant Street?
There were
Objection. Asked and answered.
Overruled. The witness may answer.
there were barricades that were partially black. They were on Main Street, but partially blocking Pleasant Street as well.
Could a car have gone down Pleasant Street?
Yes.
Objection.
Okay.
Overruled.
Hearsay.
The witness may answer. It's not hearsay.
So when the red SUV came down White Rock Avenue and was making its turn onto East Main Street, as you testified, it could have just gone straight onto Pleasant Street, correct?
That is
Objection.
correct.
It's hearsay. She's speaking as a
Hold on.
eyewitness,
There's an
first-hand
objection.
eyewitness.
Mr. Brooks,
You don't
your
know
objection is noted.
Hearsay.
It's overruled.
Dumbass.
The witness
As
may
usual.
answer.
It's always overruled.
Go ahead. You may answer me.
Sorry, there's a lot of talking. Your question was, just to clarify, could the vehicle have gone straight onto Pleasant Street? Is that right?
Yes.
Okay, yes.
Okay, thank you. And where you stated that you and your kids were partially in the roadway when the red SUV came through?
Yes, we were.
Objection. That's
And
mischaracterization of what was testified to.
Overruled. The witness may answer. Go ahead.
Give me an answer.
Can you repeat it?
Sure. Were you and your kids all in the roadway when the red SUV went through?
Yes, we were.
Okay. You weren't part of the parade, correct?
We were not.
Okay. So were you standing with other people that were in the roadway?
Yes, we were.
And was one of your kids going to get candy when the red SUV came through?
Yes, my
Objection.
daughter.
Speaking as a first-hand eyewitness.
Because she is a first-hand
Objection.
eyewitness.
I'm talking about you.
The objection is noted. It's overruled. The question is proper, and the witness may answer.
Yes, my daughter was further in the roadway. We were all in the road, but she was further in the roadway, reaching to grab candy.
At any other time, you stated that this was towards the end of the parade. Is that correct?
Yeah, we saw Santa, and he's always like the end of the parade.
And had your daughter gone to get candy at other times?
The entire time.
Had she, during the time preceding the red SUV coming through, had she almost been struck by any other participants in the parade?
No, she was nowhere near like where the vehicles were driving through the parade. She was, no.
So she's going out to get some candy that had been thrown, I assume, correct?
Yes.
And
Overruled, the witness's answer may stand.
you see this red SUV coming. Is it coming from your right or from your left?
The red SUV was coming from my right side, which was White Rock.
Okay. And how close did it come to your daughter?
It was, I wouldn't be able to give an accurate judgment, but it felt very, very close.
Had you not pulled your daughter away, would that car have hit your daughter?
It's actually speculative.
Overruled.
It's very possible.
Yeah, and you've been told that you can plead on cross.
So you say that you saw a police officer have some contact with the red SUV. Do you recall that?
Yes.
Can you describe that for the jury?
Well, there was a few times that police officers attempted to stop the red SUV. The first one would have been where we were on Main and White Rock. And then there were also other people trying to stop it too. And then again, as it drove, once it turned onto Main, the next road, I believe is Buckley. And there was another officer who tried to stop that, the red SUV again.
And which is the officer who had to step out of the way in order to not get hit by the red SUV?
What was the question?
Where was the officer located who had to step out of the way to avoid being struck by the red SUV?
I believe that was the officer around Buckley and Maine.
Okay. And ma'am, as the car passed your location, did it increase its speed?
Yes.
Do you know where in the roadway it traveled down?
Overruled, the witness may answer.
The direction of travel?
Where in the road? Was it on the left-hand side, the right-hand side, or in the middle?
It was all over the road.
You saw it all over the road?
Yes.
So going, and why don't you describe for the jury what you saw?
Driving the vehicle, once it turned onto Main, it drove side to side, and then I lost sight when there were through the people as it got down the hill.
Nothing further.
Thank you. Let me read the rest.
Yep. You said you observed multiple officers try to stop the vehicle. Is that correct?
Yes.
You described one at, I think you said it was Buckley, right?
Yes.
Why didn't you report the other officers that you allegedly saw attempt to stop the vehicle?
I don't know what you're asking.
The report that the interview that was conducted with the FBI. That was who did your interview, correct?
Yes.
Why is it not in the report about the multiple officers that you say you saw attempted to stop the vehicle?
I don't know why that wasn't put in the report.
Do you recall if you told the FBI agents?
It's been a year. I believe so, but it's been a year.
when you say it's been a year, I'm assuming that means that there's some details you don't quite recall all the way. Would that be fair to say?
Yes.
So it would be fair to say that if there's details you don't recall, how can you recall the path of travel of the SUV that you claim you saw?
Can you rephrase the question? I'm not understanding.
I think it was clear, but I'll ask you.
You think it was clear for you?
You just acknowledged that there may be some details that you don't quite recall. So would it be fair to say that you don't quite recall the path of travel of the vehicle?
No, that is not correct.
Judging by what you just stated, wouldn't it be fair to say that that's a possibility?
No.
So you recall all the details of what you observed that evening, November 21st, 2021?
No.
So what other details do you not recall?
You're under, how does someone recall the details that they don't recall?
Yeah, that's what I wonder.
Sustained is to the form of the question.
Seems very funny.
Nobody can answer the question.
Seems almost as if you're recalling what you want to recall and purposely not recall.
Objection,
Don't-
badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Badger or argue. What do you mean?
Next question.
What do you mean?
Don't intimidate the witness is what I mean.
How am I intimidating the witness?
Badgering the witness by eye rolling, by pursing your lips, by making facial movements regarding her
Does she
answers
feel intimidated?
is badgering the witness.
Are you kidding me?
Under 90611,
You really
please
can't- you
ask
really
your
can't
next
be serious.
question.
You can't be serious right now. Intimidating the witness. What have I done to intimidate the witness?
The last question was badgering, which is a form can
But you
be.
said
Mr. Brooks, I
intimidate.
made my ruling under 90611.
You specifically
Please
said
ask a
intimidate.
question or
I'm trying
I
to
will
merely-
stop the
How did
questioning.
I intimidate?
Under 90611, sub 1, sub A, sub B, and sub C, ask your next question
You
for the questioning of this
How are
witness.
you even a
end.
judge? How are you even a judge?
All right, you may step down, ma'am. Thank you.
How are you even a judge? Come on, man. Be the beneficiary of.
I'm going to give the jury
What?
their closing instruction. We are done with testimony for today. Please do not begin your deliberations and discussion of the case until all the evidence is presented, and I have instructed you on the law until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, filled out a subpoena for Don Woods, and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously, she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her, and she was under state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If I want her to be here, she gonna be here.
I agree with the state that.
Just know that.
She could certainly appear.
It ain't even got to be no arrangement. All I got to say is come. She gonna come. That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you to have her here at 9 a.m.
We said all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a judge?
Mr. Brooks, I need to make a record of
I need to make a record too.
You don't.
When am I going to get the chance to do that?
All right. I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make. He hasn't sat down for the better part of 2 hours.
All you want. You can hold me in contempt all you want.
I'm not holding you in contempt.
If it's criminal or civil, so I can hit you with you.
I need to clear the courtroom because I do need to make.
I'm gonna give you what you know is coming.
I need him to go to the other courtroom because I do need to put some things on the record. The record should reflect
contract between you and I?
that Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what
He is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being taken to the next courtroom.
Mr. Brooks, don't try to address me like that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's system.
Tacit is not a word. No, his mama did not show up to court.
Witness. It was apparent to me that he was not pleased with some of the rulings that I had been making regarding objections. I would just remind him that this was a witness he called, therefore it's proper and allowable under the law, under 906.11, sub 3 to be exact, for the state to ask leading questions, which they did. And at the very end of that, there was an objection based on badgering, which, as the record reflects, I sustained. His voice got louder. He continued to stand. He was being very argumentative with that witness who, again, he called. Given his posture, given his staring, given his pursing of his lips, given the way that he kept asking the same question in different ways, but over and over, not satisfied with the responses that had been given or the court sustaining the objections, that is why I made a finding at that time and sustained the objection for badgering. It was Mr. Brooks who asked me what that meant, and I indicated it's a form of intimidating a witness. I don't mean that in the sense of there's a charge of intimidating a witness. That's not certainly what I meant, but really in the common everyday usage, it's another word. It's a synonym for badgering. Clearly he was displeased with the court. After that, I cut off the examination, which I had given a number of warnings that I would do if he didn't ask an appropriate, a probative, a relevant question. During that time of both the, frankly, even during his direct examination, definitely during the state's cross-examination and then redirect, it was very apparent to this court, and I think to anyone who was watching, that Mr. Brooks was not pleased with the witness's answers and would roll his eyes at her, or just to himself, I guess, and purse his lips and make other gestures that he did. That it was apparent to this court he did not like her testimony. And again, I'd remind everyone that it was his witness, and he had the police reports for this witness, and obviously was fully aware of her statements to the investigators in this case. So I just wanted to make a record of that. It's in part why at the very end, and given the history of today and his conduct and being removed previously, I thought it important that the court remove him at the end of the hearing outside the presence of the jury so that I could get through a couple of things. We have gotten through the witnesses for which Mr. Brooks issued subpoenas that the state assisted with. I did provide permission to him earlier today, if he so chooses, to call Dawn Woods as a witness. The only other witness at this point that I can identify that's been, for which there is, for which the court and the state has been put on notice, of course, would be Mr. Brooks himself. I'm not looking for an answer today, but what I wanted to put on the record, and what I will put on the record, are certain advisements that he can certainly contemplate over the weekend, so that when I do the colloquy with him on Monday morning, he's had a sufficient opportunity to think about his decision to testify or not to testify. The advisements that I will give Mr. Brooks at the moment are as follows. Mr. Brooks has a constitutional right to testify.
He's not listening.
If he chooses to testify, I'm further advising him that the state has the right to ask questions of him, what is referred to as cross-examination. That may include reference to whether he's been convicted of crimes in the past. I still need to make a ruling on that, and I will do that first thing Monday morning. I will also advise him that he has a constitutional right not to testify, and that a decision not to testify, that a jury will be so instructed, not for that, they will be appropriate jury instruction on that. If he chooses to testify, the other jury instruction that is typically read simply advises the jury to assess credibility no differently than how they would assess the credibility of any other witness. There's the added paragraph to jury instruction 300. I would further advise him that it is his decision and his decision alone on whether to testify. I will ask him whether anyone has made any threats to influence his decision on whether or not to testify. I will ask him whether anyone has made any promises to him to influence his decision to testify. I will rely upon upon the record, specifically the record made during the waiver of attorney regarding his education. I will ask him whether he's had any medication, alcohol, or drugs within the last 24 hours prior to the colloquy. And I may also confirm that he's able to read, write English. Again, I may also refer back to the colloquy I had during the waiver of attorney hearings. I will then ask him whether he's made a decision, and then ask what that decision is. And then based upon his decision, I, of course, will make an appropriate finding. Given how this trial has progressed and the disruptions and some of the issues with, excuse me, consent or lack of consent, or that Mr. Brooks sometimes raises, I'm also going to advise him today that failure to answer the question on what is your decision, a failure to answer, this court will interpret as a no, meaning he will be choosing not to testify, and the jury will be so instructed. And I may ask that question more than once, depending on the circumstances. I'm also going to direct the parties to some cases that I think may become relevant about potential testimony, the scope of it. Chambers versus Mississippi. It's a U.S. Supreme Court case from 1973, found at 410 U.S. 284. Rock versus Arkansas, also a U.S. Supreme Court case, 483 U.S. 44. State versus Anthony, which is a Wisconsin case, 2015 Wisconsin 20. These cases, of course, recognize that a defendant in a criminal case has a fundamental constitutional right to testify in his or her own defense. Of course, that right stems from various constitutional provisions, including the 14th Amendment, which protects the defendant's due process rights to be heard and offer testimony. The 6th Amendment, which protects a defendant's right to call witnesses and right against compelled testimony unless he chooses to speak on his or her own behalf. I'd also point the parties to State versus McDowell, 2004 Wisconsin 70. Although the right to testify is a fundamental constitutional right grounded in personal autonomy, it is not absolute. 26 Wisconsin 2nd 315. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Citing to Rock versus Arkansas, there's a balancing test that if and when this court is faced with any of these situations that I will be prepared to go through. Of course, Illinois versus Allen is also important, and all of the other cases that I've cited along the way. State versus Anthony is also important, as I've noted previously. I've relied heavily, of course, during the course of this trial on 906.11. And the primary purpose of a criminal trial is to develop relevant facts on which a determination of guilt or innocence can be made. Efficiency is a secondary objective of trial. And of course, it is the circuit courts and the judges assigned to those circuit courts that are charged with administering the trial and serving these two purposes. So, just tying up, I guess, the last loose end. I've referenced it already, but I think it's worth repeating again. If the defendant wishes to call Ms. Dawn Woods to the stand, I expect her to be here. I expect one of two things to happen. Either he testifies first or he doesn't, or he calls. He can certainly call her after he testifies, but if she is not here at 9 o'clock, when I've advised the jury to be here, I will, of course, have gone through the colloquy with Mr. Brooks, and I expect people to be on time and to be ready to go, to be fully prepared. And then, of course, the state, if it so chooses, does have the option to call rebuttal witnesses and often anticipate that. I appreciate that because once the evidentiary phase of the trial is closed, of course, I will be sending the jury home because I do anticipate a very lengthy jury instruction conference. It's my hope that that is something we can get done by the end of the day on Monday, but since it's just the parties and not a jury here, I will go as late as it takes with the hope of and with the plan of, again, assuming the state doesn't call any rebuttal witnesses, to start instructing the jury on Tuesday morning. I anticipate that is going to be an incredibly lengthy process. We have been working, Madam Clerk has been working very hard on pulling together, just from what we have thus far, the jury instructions. I believe it's well over 100 pages, Yes, with my advanced eyes, I need 14-point font. So with that caveat, but the preliminary instructions were 69 pages with the 14-point font. So I know it's going to take some time. I know I'm going to need some breaks. I do not anticipate getting done with, so I keep saying preliminary, but I don't anticipate getting done with the advisement of the jury instructions before the lunch hour. I can't tell you how long it's going to take. It may take the whole day, but the party should, well, the state would go first, so the state should be prepared, perhaps to start closing arguments. I'll ask you at a later point, probably sometime on Monday, if you have an idea of how long that will be, because that will frankly dictate in part like where we are with how long it takes for me to go through the instructions, and whether I just instruct and then bring the jury back the next day for closing arguments. But that's generally the framework that I intend to follow. Any questions about any of that from the state?
Nothing about any of that, Your Honor.
Anything you think I need to address before I turn to Mr. Brooks?
We do have two things to clear a record about.
Go ahead.
Do that now?
Yep.
The first is for the testimony of two different witnesses. We provided Mr. Brooks with summaries of those witnesses' statements as recorded in the police reports. First was Deanna Aldrich. That included a piece of paper containing 3 paragraphs which summarized Ms. Aldrich's statement to the Waukesha County Sheriff's Department. Supplement number 55 under an incident report number of W21087731. The second of those was a 1-paragraph summary of the statement provided by Jason Hayes to the City of Waukesha Police Department, memorialized in supplement number 28 under incident report number 21047-493. These were, again, documents that were provided to Mr. Brooks in the discovery process, but we sought to be helpful in his presentation of evidence here at the trial today. The second issue that we'd like to make a record about relates to the testimony of Erica Patterson. So for the record, I think it's important to note that the 2 photographs the defendant attempted to show that witness and presumably put into evidence depicted what I believe to be the defendant and Ms. Patterson's 15-year-old daughter, as well as their new grandchild, the daughter's child, who was born around May 1st of 2022. I think that there was ample grounds for the court to end Ms. Patterson's testimony when it did, but for just in case that becomes an issue going forward, I'll make an offer of proof that Ms. Patterson, if asked about those pictures, would have testified that she did not provide them to Mr. Brooks. She provided them to a person named Michelle, who I believe is a mutual friend, who in turn provided them to Dawn Woods, the defendant's mother, long day, who then, that was the person who provided them to Mr. Brooks. If she were forced to answer questions about this supposed letter that Mr. Brooks was claiming to exist, she would have testified that she has not written a letter to Mr. Brooks since he came into our jail on November 22nd. She didn't write one on November 21st either. At any point between his being taken into custody and today. It's my understanding that he has tried to call her from the Waukesha County Jail on 37 occasions. She has never accepted a single one of those phone calls. And finally, during the early lunch break, I was informed by the bailiff staff that the defendant was twice offered to go to his cell to retrieve that letter that he talked about. He declined both times.
Thank you. I appreciate the record being made. I will now unmute Mr. Brooks and ask him if there's anything he needs to make a record of at this point on the topics that have been raised. Sir, this anything you wish to address before we break for the day?
Yeah, I wasn't really hearing everything that was just said good, but why haven't I been given the chance to offer all my filings and the evidence when I already stated that before? I would like all my filings. I would like every single filing that I filed placed into evidence. Every last one of them.
What
That
filing
has yet to be done.
talking about?
I put you on notice and I've stated it on the record. Even before I even had a chance to start calling witnesses and put on a defense that I haven't even been adequately been able to do. So this is something that's been stated on the record numerous times. I did hear a reference to what was he just talking about? Whatever he was just talking about is in regards to me going to get the letter or whatever the case may be. First of all, it's not just one letter. Like I stated before, it's multiple letters. And for somebody that don't even know to try to tell me what I got, like you need to cut it out, man. Y'all need to cut it out. Seriously. Stop it. It seems to me that all y'all been wanting to do is gang up. Be biased, be prejudiced, and gang up.
You're so stupid.
4 against 1.
It's called justice.
You sit up there earlier and made a record before the lunch. You sit up there and made a record about all this stuff that happened in Nevada. That's other acts evidence, ain't it? How was you allowed to put that on record and not even be truthful about everything that you said? But not one time did somebody say, no, we're going to strike that. Not one time. But if it had been me, it would have got struck. Or if it had been me, it would have been a problem. If it had been me, I'd have been held in contempt.
You have never been
Why
held
was the
in
bond not
contempt,
addressed?
stupid.
Why was the statement of particulars not addressed? No filings that I seem to file.
You think you
Need
know
to be
so much,
addressed.
you know nothing.
After you sat there and told me that that's what I needed to do, do you want to refer to the waiver of counsel, which, again, for the record, you accepted it the way that I gave it to you, which clearly states on there, I do not waive my right to assistance of counsel, and you accepted that. But you still turn around and continue to violate my Sixth Amendment rights.
Wisconsin.
You violate my First Amendment rights by telling me what I can and can't say, which I have the right to say whatever I want to say and to be heard. That's the First Amendment. You sit up here and talking about a fourth option that you came with out of the blue for Illinois versus Allen when there is no fourth option. Then you try to seek some other case laws in that you just came up with today. I don't know if you came up with that when you was on one of your breaks that you take, but that it's awful funny that it never got mentioned before. You've repeatedly made a false record. You want to sit up here and perpetuate all this disruptive behavior and this, that, and the third, when you knew from the point of the start of this trial, 1, that I wasn't prepared, 2, that I did not understand the proceedings. But yet still you choose to find a way to get around it. just like you found a way to get around answering what your name was, which you're a public servant, the name that you have on file with the Secretary of Treasury and State, however you want to put it. You were asked for a certified copy of your oath of office, which you stated on the record you would not provide. Didn't give any case law why you don't have to provide that.
But she doesn't
Have yet to prove subject matter jurisdiction, for the record. Have yet to show that you even have a license to practice law. Haven't proven that yet.
Notice
It
how
either
she's
has the
not interrupting you.
Where's the licenses? Why can't I place your oath of office into the record? Why can't I make that part of evidence?
You don't have to.
The oath that you haven't even honored, not one bit. Doing enough to keep your face clean doesn't constitute
How
being
insulting.
fair. Doesn't constitute being
So
impartial.
insulting.
When the jury was selected, I struck the whole jury. That never got
Of course
addressed
you
in
did.
any way, shape, or form. When you were informed way before that I was striking the whole jury. So how can you go over that constitutional right, which I have the right
Struck the whole jury. I'm not
to not pass the
surprised.
jury?
Mr. Brooks, I'm muting you. And the reason I'm muting him is because he has not addressed a single issue that was raised at the end of this hearing today. He is simply rehashing previous determinations of this court. I would describe it as a rant. He continues to impugn the integrity of this court and this process. Again, he did not address any of the issues that I raised at the end of this hearing. From my perspective, the issues that he is raising are all related to claims that a sovereign would make, someone who claims to be a sovereign citizen, claims that have no base, that are baseless in law and in fact. I'm not going to address them any further. Again, they are simply baseless. And with that, I'm going to end for the day. I'll see the parties at 8:30 a.m. on Monday. Thank you, everyone. We are in recess.
Okay. Day 12. Now I gotta find day 13. Day 13. Looks like we started watching it because Shadow decided we needed to skip to the middle of day 13 for no reason. If he's cooled off over the weekend.
Present in person, in custody. However, he is wearing street clothes, a suit and tie, and a mask.
For the record, I don't consent to being called that name.
Yeah, of course you don't.
It is noted. All right, Mr. Brooks, just preliminarily, do you anticipate calling any additional witnesses today?
For the record, I don't consent to being called that name. And what was the question?
Do you anticipate calling any witnesses today?
I don't believe today.
Well, we are here for the continuation of testimony. The only witness that I'm aware of that's on your list that you added is, so I would expect that if she's going to testify, she would be here. Otherwise, I will be going through the colloquy with you as to whether you intend to testify today or not.
Did you receive my ICS that I addressed to you?
Oh, I haven't looked. Let me look.
Actually, I just one to you and then one to the prosecution.
Is the audio on?
It is. The audio's on. Do you know when you sent those?
Saturday. So that would have been the 22nd.
State receive anything through, like, the inter-office communication?
We have not, I just checked this morning to see if there's anything new. Nothing has been received at my office. And I should say the clerical that was assisting me went to the mailroom to double check. So not only has it not made its way to the DA's office, it hasn't even made its way over to the mailroom.
I can email the jail administrator to find out if there's anything in transit, if there's no objection from the parties, from the state.
No objection?
From you, sir?
No objection. I definitely want those documents received if they obtain important information.
You said you forwarded them to a staff member on Saturday?
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe afternoon.
Two ICF form?
Yep, one addressed to you directly and one addressed to the district attorney's office.
I'm sending that. I will send it with high importance and we'll see what response I get. But I don't have anything. If you want to generally tell me the topic, we can cover it verbally.
The topic is pertaining to exculpatory evidence. Some things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
All right, what information? Make an offer of proof for me, sir.
The expert witness for the prosecution in regards to, I believe it was inspecting the vehicle, Officer Ryan Schultz. Question was asked of, did he know if there were any recalls on that vehicle? And I believe that a Brady claim should be visited because there were in fact recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford Company were sued because of this, and those vehicles models from the year 2008 through 2010 were recalled. And that is very important information in regards to the vehicle in question being a Ford Escape 2010. This information is very easily obtained just by pulling it up, and you'll see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to.
So what's your request, sir?
My request is to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles, and
in light of the fact that these vehicles were recalled because of this malfunctioning throttle body for I believe it's counts 1 through 73 to be dismissed.
All right, what's the response from the state, if any?
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit. Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem. That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway Traffic and Safety Administration, there are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls. So it's a mood issue.
I don't believe it's a mood issue, and I actually have, the report should be in the mailroom as we speak. I had everything sent over prior email, the actual information about the class action lawsuit, the actual information about the recalls for those models. Like I said, 2008 through 2010. Now, in all fairness, Your Honor, I was asking for a Brady claim on this. Seeing as how when vehicles are purchased from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens. And seeing this a class action lawsuit, no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if these vehicles were not malfunctioning. And I believe with that, like I said, the information is easily obtainable. I should have the information in the mailroom right now, that you can readily view this information about the class action lawsuit, about the recall. It wasn't just the 2010 model in question, it was 2008 through 2010. The information about the malfunctioning pertains strictly to the throttle body.
Let me address your claim, sir. So, not trying to cut you off, I don't need the specifics about a class action, because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls, and more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email, it's one page with what you said. I have to turn my head, I gotta figure out how to flip it. So give me a second.
Okay. And just for the record, Your Honor.
Hold on, let me finish my record, okay? So I'm going to turn, because it's the only way I can read it. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital. I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother, and from my understanding of recalls, I think what is common knowledge is that information regarding the recalls and what to do, and presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function during the incident in question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case, and I'll deny the request to recall this witness.
Your Honor.
Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him and was asking questions directly related to information contained in that report.
All right, go ahead, Mr. Brooks.
When you spoke to the owner of the vehicle, that's who gave me the information.
my mother gave me the information of this. I had no knowledge until she told me. And that's how I came into the information. And she was the one that said, I'm going to send you all the information that you need so you can present it to the court. So I
understand that, sir, but your request is not timely. So you have had this information for quite some time, either through counsel.
I did not have it for quite some time.
Let me make my record. Either through counsel.
It was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but even when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done. And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet. So how would I be able to?
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm telling you,
trust.
she just told me this information. I have the phone calls to prove it.
I understand that. I'm denying the request, sir.
And I would like a.
So that's my decision.
I object to that, Your Honor.
I understand. I've made my decision. I expect that you respect the decision, at least as we're not going to debate it further.
Yes.
I now have the ICF, the one from the state.
Addressed.
Provided for the state.
Was addressed.
Madam Clerk,
I respectfully object, Your Honor, and request the legal reconsideration of your ruling, Your Honor.
it's denied. The request for reconsideration is denied. There's no legal basis for me to do that
I
at this point.
respectfully reject that ruling and take exception to that ruling, Your Honor.
All right, Mr. Brooks, we need to keep going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Your request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
I wouldn't be the one you would make that request to, sir. So I can't
For the record, may I
answer that
move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction?
That request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact, Your Honor?
Any other requests, sir? I'd like to move on.
Based on what law?
There's no
Or
legal
fact.
basis that you've stated for me to do that, sir.
It has been, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion. So it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor. Can you show me how or where this court is following the law of respecting this matter?
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact. So this court cannot address that last statement of yours.
Your Honor, with all due respect, I would like a motion for finding a fact.
Denied.
And with all due respect.
Under what law and fact?
I made an oral ruling, sir. There's no requirement I do so in writing.
So you're denying a legal, you're denying a motion for finding a fact.
I am.
So how do I know what you're doing is legal, Your Honor?
All right, Mr. Brooks, we're going to move forward. At this time, I want to.
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward. So your request is denied.
It doesn't seem like
Mr. Brooks, I need to give you some advice.
It doesn't seem like you're. I don't need your advice.
No, I have to give you advisements, sir, regarding your right to testify.
I need to do your job without prejudice prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right to testify. Do you have a witness to call,
You don't need to go
sir?
through anything with me on record. You
Actually,
need
I
to-
do so,
Actually,
sir.
you
That is
don't.
required by law.
Actually, you don't. You need to do your job as a public servant.
Mr. Brooks,
and honor the oath that you
I
took,
need to
Your
go
Honor.
through these advisements, and if you're going to keep interrupting me, you will forfeit your right to be present, and you
So
will
you're
be
holding me in
removed
contempt
to the next courtroom so that I can properly go through these advisements without being interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with all
I
due
need you
respect,
to
in Illinois
not
versus
interrupt
Allen,
me.
in
This is
Illinois
another
versus-
interruption.
In Illinois versus Allen.
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying to
of
have a
Illinois
debate.
versus
I'm
Allen.
not trying to have a debate.
You are
I'm merely
advised
trying
that
to
it
understand
continued.
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that I'm
I've said
forfeiting
that
my
multiple
right.
times.
You
I've
saying-
given you multiple
You're
opportunities to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt.
Mr. Brooks,
By
I'm not holding
removing
you
me
in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor,
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect,
No.
in Illinois versus Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this
I'm
court
trying to
that
understand,
he
Your Honor.
wants to disrupt these proceedings, even
That's
in a
not true.
mild manner tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
the standards
because
of
it
order and
doesn't.
civility, and one of the
Illinois doesn't.
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
We'll clear the
state
courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there.
It
Again, I'll make
doesn't
the
state that
appropriate
you can be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record.
or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit agreement for something that I.
Good Lord, man. Do you really think he's that stupid that he doesn't know what he's doing? I think he knows exactly what he's doing. I think he's doing it on purpose.
Made after the fact. About 26, 27 different times he interrupted me or spoke over me. Once I made a decision on his motion to dismiss and his request to recall a witness, he then asked if for written findings. I denied that. He then asked for what law I was following. I indicated I wouldn't explain that further, that I already made an oral ruling. He asked for a stay. He asked for dismissal. All of those things I either denied or said I wouldn't answer, specifically as it relates to the request for an interlocutory appeal, since I would not be the judge or court to which a request would be made. That is something that would be made to the Court of Appeals. And although I would have authority to grant a stay pending appeal, there is no appeal that's pending. I gave Mr. Brooks multiple opportunities to stop talking. I asked him repeatedly to stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and would be taken to the neighboring courtroom. I believe I gave that warning at least twice. Of course, this comes on the record before this court over the first 15 days of trial, where Mr. Brooks has, by his conduct, forfeited his right to be present on a number of occasions due to his conduct. I do appreciate that this morning he didn't yell at me, he didn't raise his voice, he didn't speak in an angry tone. But given the history in this case leading up to today and knowing what this court needs to get through in terms of whether he has any witnesses or whether he intends to testify himself, there's a very important colloquy I need to have and an advisement of his rights that I need to go through. And I simply am not able to do that with him constantly interrupting me and then not respecting the oral rulings that are made. Of course, at any point in time, Mr. Brooks can ask to be brought back over to this courtroom under Illinois versus Allen. Of course, he needs to pledge that he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I, of course, have repeatedly, even without him making such a pledge, brought him back into the courtroom where I felt a sufficient time has passed, and he at many times has been able to conform his conduct. I would note during the vast majority of the testimony that was provided during the state's case, he was in the courtroom, if not during the entire time. He was able to cross-examine witnesses. We had a couple of issues during the testimony of witnesses he called. And of course, last Friday was, in my opinion, probably one of the most challenging days, I should say, to date. It's my hope that we can continue with Mr. Brooks in this courtroom. At some point today, I'll certainly invite him back over when I get through these advisements. Mr. Brooks, you have been muted. I will make that, put that on the record as well. I will unmute though and ask Mr. Brooks, because you did not answer the question previously, other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse to call today? I need an answer to that question, sir.
So we addressing subject matter jurisdiction that we haven't addressed when I was just over here, or since I've been over here? Are we addressing subject matter jurisdiction?
I'm going to mute him just for a second. No, I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction. I have issued a written decision on that. He has not filed any type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point his request to dismiss the case based on a lack of subject matter jurisdiction. Mr. Brooks, I will be asking you a couple of questions. I do need a response. I am unmuting you. Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
Yes. This is the jurisdictional challenge right here. So are you going to address subject matter jurisdiction and prove it for the record or not?
So I've asked Mr. Brooks twice now whether he has any witnesses to call other than himself. He has declined to answer that question. Sir, if you fail to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity, you will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any other witnesses at the courthouse available to testify right now? I'm not getting a response at all.
Am I unmuted?
You've been unmuted, sir.
You just said I was muted, so I'm not sure. I don't know when you muted me or when I'm not muted.
Well, me muting you doesn't affect you being able to hear the court, because
Yes,
that only
it does.
mutes your audio coming into this courtroom. I confirmed already
Why was my
that
audio muted to begin with?
That is simply a misstatement. I confirmed with the bailiffs that the audio and visual were working.
Why is my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here. So I trust that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning and specifically now? I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning?
Nope.
He's been unmuted though, for a while now. We can obviously hear him. I will ask Mr. Brooks a third time. For the record, he's finally putting on the headphones. Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
Why are you yelling?
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear it. I don't need to be muted.
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record, sir.
You are lying on the record.
All right, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses, other than perhaps himself. I then specifically asked him about Dawn Woods, because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that.
Probably not.
Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses. Again, other than perhaps himself, I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. I would direct Mr. Brooks to the case of State versus Anthony, although that squarely dealt with a person's right to call to be themselves a witness in their own case. They talk at length in that case about how rights, even constitutional rights, can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon conduct. Although a criminal defendant does have a right to present a defense, doing so must be guided by the rules of evidence, the rules of procedure, and also with respect for the dignity, order, and decorum that is needed in the courtroom. Mr. Brooks has demonstrated this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and a disruption tactic. When considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has forfeited his right to present further witnesses. I would like to go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that. I ask Mr. Brooks to put on his headphones if he is unable to hear me, and just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point.
Mr. Brooks, you're unmuted.
He's unmuted.
You're unmuted. You can speak directly to you on the first time to hear, and you hear it.
I've also been advised by not just the bailiffs who are over there, who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear. Mr. Brooks, I would like to go through with you your right to testify and your right not to testify. We are at the stage in the proceedings where it is important that this court conduct a colloquy with you. I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin 20. Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him, although I haven't seen a page turned. If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that? No response by Mr. Brooks. Sir, you also have a constitutional right not to testify. If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that? Once again, no response by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that? There's no response by Mr. Brooks. It's my understanding that Mr. Brooks has the equivalent of a 12th grade education, that he attended school either up to or through 12th grade, and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education. He is currently in custody, of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours, or any drugs or any alcohol?
It's not going to answer.
I'm not receiving a response to that. I'm aware that he's able to read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understand, he can read, write, and understand the English language.
Am I unmuted?
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you're going to verify it on record?
So he did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24 hours. I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial? although he turned and said, "What did you say?" Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
You saying. So if you can hear me, I don't hear everything you saying, and you know I don't hear everything you saying. So cut the crap.
Mr. Brooks has interrupted with very disrespectful words at this moment. I believe that he is feigning his inability. He's done so throughout this case. There's absolutely while in this courtroom he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio that it mutes his audio are simply false.
So
Mr. Brooks, have you made...
Am I still unmuted?
You are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder than it is in this courtroom.
You need to stop making false records saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here. That's what I said. So I would appreciate if you would make the record clear and correct.
Clearly, he heard me say that for him to make that distinguishing statement.
I'm sitting right here. Don't you see me looking all up to the microphone so you can hear me?
I don't have an issue hearing you at all, sir.
Can you hear me when I'm right here?
I can. Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
No. Have you made a decision to tell
I will
me
ask you again, sir. Have you made a decision to testify in this case?
To address subject matter jurisdiction? Have you made a decision to be impartial? To answer what your name is? To answer if you have a claim against me or don't?
I'm going to mute him for the moment just because, once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with him regarding his right to testify. He is asking me about subject matter jurisdiction. He's making statements about this court that are disparaging and about my oath. Again, a clear attempt, in my opinion, to simply stall these proceedings and to disrupt them. I will unmute him and I will ask him for a third time with the understanding that if he fails to answer the question in the affirmative, I will interpret his failure to respond as a no and that he is not going to testify. So once again, I am unmuting him. Sir, have you made a decision on whether to testify in this case? There's no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case?
Am I unmuted?
Yes, you have been. Sir, do you want to...
How long have I been unmuted?
Sir, do you want to testify in this case?
When I had the headphones on just a minute ago, you just said you was muted. So when have I become unmuted? Or did you even mute me in the first place?
Mr. Brooks, I'm asking you one last time. Do you want to?
Because I haven't heard nothing that you asked. So how you gonna ask me something and then just answer for me?
Mr. Brooks, do you want to testify? All right, I'm going to answer. I'm going to mute him again. Again, it is very clear to this court that he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears this court and that he's choosing to willfully not answer this court. This court, as I indicated earlier, is tasked with the duty to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions. I personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make the appropriate findings. Without him providing answers, this court is left with no choice but to find that he is forfeiting his right to testify on his own behalf. This court must also preserve dignity, order, and decorum. Again, ensure relevant and admissible evidence is presented, and also honor the defendant's right to present a defense. The simple requirement that he answer questions is required, frankly, due to the defendant's prior conduct throughout this trial. His repeated defiance, his repeated outbursts, his repeated failure to follow simple rules of courtesy and decorum, his repeated interruptions of this court, and this court having to repeatedly remove him to the neighboring courtroom and making findings that he has forfeited his right to be present. Of course, this record is abundantly clear at this point that Mr. Brooks is not even in the main courtroom, because this morning alone, he is yet to conform his conduct to the simple standards of courtesy and decorum that are required of all participants in these court proceedings: the court, the prosecutor, the defendant, the jurors, the public. Absent an adherence to these simple rules, including the rules of evidence, the rules of procedure, and the rules of civility and decorum, and without a pledge by Mr. Brooks that he will follow these things, then on balance, this court will find that he has forfeited his right to testify. I've now made a much more full record of what is at stake, and I will give Mr. Brooks an opportunity again to go through the colloquy with the court regarding his right to testify. I am unmuting him and will attempt to go through this procedure once again. If he fails to answer these questions, then he is forfeiting his right to testify by his own conduct. I would acknowledge that such a procedure is certainly not ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced to make this determination. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Mr. Brooks, are you aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
Mr. Brooks, do you understand and are aware that you have a constitutional right not to testify?
I don't understand. No, I don't understand.
Are you aware that you have a constitutional right not to testify?
I don't understand, and I'm not aware, so why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify, and that if you choose to testify, that you would be subject to cross-examination by the state. Did you hear me say that?
I don't hear you say anything. I don't understand what you're asking. I don't.
He is willfully choosing not to answer that. Sir, you are also advised that you have a constitutional right not to testify.
Your Honor, with all respect, you've been trying.
Did you hear me say that?
Questions for, I didn't hear you ask me anything.
Sir, stop talking and I'll ask it again. Sir.
Can you ask me to stop talking
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do this one last time.
I can hear them. I got the headphones on.
All right, then let's.
Obviously, you can see that.
Once again, Mr. Brooks is being disrespectful. He is blurting out information. He reverts back to subject matter jurisdiction. He accuses this court of not honoring its oath. He just accused me of practicing law without a license. This court has simply tried to no avail to get Mr. Brooks to answer simple questions, confirming on the record that he has been advised that he has a constitutional right to testify. and that he also has a constitutional right to testify. I was very clear prior to unmuting him and telling him that I would go through these questions once again, that I needed him to follow the rules of decorum and civility and not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. He reverts back again to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. The record is full of his tactics in this case. He would not pledge to be civil, to be courteous. He would not pledge to honor the rules of evidence or the rules of procedure. He would not even answer simple questions regarding his right to testify and whether he heard that or not. And based upon, pursuant to State versus Anthony, and looking at the balancing test that this court must consider, this court simply cannot allow Mr. Brooks to get on the witness stand unfettered without an acknowledgement that he will honor the rules of procedure, that he will abide by the rules of evidence, that he will honor rulings that are made by the court. He has demonstrated repeatedly throughout this trial that when this court makes a ruling that he disagrees with, he tries to engage the court in an argument about the legal basis, even though I've provided the legal basis on the record, or in the case of subject matter jurisdiction, even when there's a written determination on the issue. When looking at State versus Anthony, this is a case where the Wisconsin Supreme Court was faced with a similar situation, although not as egregious as I would say here, because in State versus Anthony, that was not a case where the defendant was ever removed from the courtroom based upon his conduct. Although in State versus Anthony, they noted it isn't a requirement to forfeit your right to testify to previous to that be removed from the courtroom. So not as egregious as a case, but this court has a history over 15 days of trial where Mr. Brooks has repeatedly been removed from the courtroom, where he has repeatedly demonstrated he has absolutely no regard for courtesy and decorum. He is what I would describe as a stubbornly defiant individual who simply wants to say what he wants, when he wants, without a filter, without regard to the rules of evidence and the rules of procedure. As State v. Anthony discussed, the right to testify, although a fundamental constitutional right grounded in personal autonomy, is not absolute. For example, there's no constitutional right to commit perjury. There's no constitutional right to present irrelevant evidence. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Those restrictions, again, fall primarily under the rules of evidence and the rules of procedure. The court in Anthony cited the U.S. Supreme Court from Arkansas versus Rock, wherein that court stated the right to present relevant testimony is not limitless and may in appropriate cases bow to accommodate other legitimate interests in the criminal trial process. For example, numerous procedural and evidentiary rules control the presentation of evidence and do not offend the defendant's right to testify. Throughout this trial, Mr. Brooks has repeatedly accused this court of violating his First Amendment rights of free speech. I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited in the court of law for the very reasons cited by the Supreme Court in Rock. The takeaway from Arkansas versus Rock is that a defendant may forfeit his right to testify by his conduct, whether a criminal defendant may forfeit his or her right to testify through conduct incompatible with the assertion of a right was reviewed by that court. That court went on to discuss waiver and forfeiture, and ultimately went on to conclude the following. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. The balancing test that this court must go through are the interests, again, as I've already stated, for the rules of evidence, the rules of procedure, civility, and decorum, and balancing all of that against Mr. Brooks's right to testify. This court is not making an arbitrary decision. The decision I make here today is, in my opinion, proportionate to the conduct demonstrated by Mr. Brooks throughout this trial, and specifically today, based upon his failure to even engage the court in a simple colloquy regarding his right to testify and his right not to testify. He was repeatedly warned that the failure to answer the questions would be taken as by this court really as no, meaning the specific question, have you made a decision? And as for all of those reasons that this court will make a finding, he has forfeited his right to testify. With that, then, there are no other witnesses to present for the defense. Before I bring the jury out, I'll ask the state if you intend to call any rebuttal witnesses.
We have no rebuttal case, Your Honor. Thank you.
All right. I would like Mr. Brooks to be brought back over so that he is present in the courtroom when the court advises the jury that the defense is resting. I realize that will be over his objection. I'd ask that he honor that. Mr. Brooks, I'm going to unmute you. If you can pledge to this court that you will honor that ruling and that you won't challenge that directly in the presence of the jury, I will bring you back over for that. Are you willing to make that pledge, sir?
Make what pledge? I'm not making no pledges.
Sir, you
asked me a question I can't answer.
Yeah, no, go ahead, answer.
You're trying to coerce me into violating my right to remain silent. How can you coerce me into my right to remain silent? So you're not going to protect my constitutional rights? Because I didn't answer nothing that you was trying to ask me before when I had the headphones on, and you can't make a decision for me. You can't do that. You're violating my constitutional rights.
She's not stupid.
Sir, if you'd like to testify, then you need to simply go through the colloquy with this court, which I've given you 3 opportunities to do, and you have decided not to.
No, you can't tell me what I decided to do, because I didn't decide to do or not do anything.
Are you willing to?
Your Honor, by law, you cannot coerce me.
I'm not coercing you, sir.
Well, you're making a decision for me based on something that I did not say myself.
Last Friday, I specifically directed your attention to State versus Anthony. I discussed very briefly at the end of the day on Friday the case law that is relevant on this topic, including State versus Anthony, Rock versus Arkansas, and Chambers versus Mississippi, to specifically put you on notice.
Did you recall what was going on Friday?
Mr. Brooks, I'm going to mute him. Again, I'm not going to have a debate. I've made a finding. I've given him yet another opportunity. If he's willing to go through the colloquy with the court, he wants to challenge me instead and saying he doesn't consent. His lack of consent to this entire procedure is noted for the record. Based on his inability to pledge to this court that he will honor that ruling and be respectful of the jury, I'm going to leave him in the other courtroom. The jury's going to be brought out, and he will remain muted, and I will simply advise them, as I have throughout this case, that he's appearing from another courtroom and that his appearance from the other courtroom should not in any way be held against him or influence their verdict in any way. I will tell them that there are no further witnesses for the defense, and then I'll ask the state if there is any rebuttal, and then the jury will be excused for the day, because we will have I anticipate will be a very lengthy discussion on jury instructions. Again, I will advise Mr. Brooks that if at any point in time he wants to come back over, he needs to advise the bailiffs, but it does need to be accompanied by a pledge that the rules of civility and decorum, and he will not specifically challenge the court's rulings regarding closing off of his ability to call witnesses or testify on his behalf. All right, let's have the jury brought out.
All right.
And we are watching this charging conference. 'Cause I think that's when he makes the bucks for it, isn't it, Judy? Oh man, it's almost 5 o'clock. Is he talking to somebody or is he talking to himself?
Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, at the moment, Mr. Brooks is appearing from another courtroom. This must not be held against him in any way and must not influence your verdict in any manner. At this time, I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal evidence to present.
No rebuttal, Your Honor.
All right, then with that, I will declare the evidentiary phase of this trial concluded. I'm going to excuse the jury for the remainder of the day so that the parties and I go through all of the jury instructions, and I anticipate bringing you in tomorrow morning. Instructions may very well take most of the day. My hope is to then have the closing arguments and then have the case be turned over to the jurors. If not by tomorrow evening, sometime Wednesday morning or early afternoon. With that, I'll rise for the jury then. Please turn your notebooks into the civilian bailiffs. I'll get them back to you during deliberations. Thank you. Be seated. Before we begin, I will have Teresa print off what at least we do have for both parties. I'd like to take a short comfort break. I'll invite Mr. Brooks to come back over, and then we'll start with that jury instruction conference. We'll take about 10 minutes. Thank you, everyone. We are in recess. come to this courtroom. I'm going to put him under oath and have him testify about the audio. I also have information from Zach Tremaine, our IT specialist. He too will take the witness stand. And I just want to make a full record of, he did a decibel reading regarding the audio as well. All right, we have Deputy Kibler, if you could take the witness stand, please. Sir, could you please raise your right hand? Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
It is.
Thank you. Please have a seat. Please state your first and last names for the record.
First name is Nicholas, last name is Kibler. First name Nicholas, last name Kibler.
Thank you. And you are a Waukesha County Sheriff's Deputy?
I am.
And have you been assigned to work this case?
I have.
And were you present in courtroom 20 this morning with Mr. Brooks when he was removed from this courtroom?
I was.
And did you make any personal observations regarding the audio and visual setup that we have over there?
Both the audio and visual were working properly. The audio was a lot louder than it has been in the past while we were in that room.
Any hearing the court?
Briefly, Deputy Kibler, the defendant asked many times if he was muted or unmuted. Do you remember that?
Yes.
Can you confirm that even on the occasions when his microphone was muted, the audio in the courtroom continued to work?
It was.
And at any time while Mr. Brooks was muted, or even if you didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not. He is telling us he prefers right now to be in that courtroom. He did not want to come back in here.
All right, thank you. Those are all my questions, Your Honor.
Mr. Brooks, you are unmuted. Do you have any questions for this deputy?
No.
All right, thank you. You may step down. You can also take the witness stand. Can you do a
Sorry, guys. StreamYard wigged out on us.
do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? All right, thank you. Be seated. State your first and last name for the record, please.
Zachary Tremaine, Z-A-C-H-A-R-Y. Tremaine is T-R-E-M-A-I-N-E.
All right, and what is your position with the Clerk of Court's office here in Waukesha?
I'm the IT coordinator for the Waukesha County Circuit Courts.
Were you in courtroom 20 this morning following Mr. Brooks being taken to that courtroom?
Only temporarily. I was there when the call started, and then we came back to do a measurement of the DV meter later.
There's a document or a photograph that's displayed on the monitors throughout this courtroom. Can you tell me what we're looking at?
So my phone is in the photo, overlaid on top of what we call the X panel. It is our AV control panel. So you push buttons on it and actions happen in the courtroom, AV related. At that time of the photo, my phone is registering 67.3 decibels in that courtroom, and that was when the judge or the court was talking, and then the sound was coming over the speakers in the other courtroom.
And what, if anything, based on your training and experience, can you tell me 67 decibels means?
It's plenty loud. For comparison, I did a quick reading in the media pooling room, which is CG6 in our courthouse. The meter there was reading between 55 and 65. So it's louder than the audio feed going to the media right now.
All right, thank you. Any questions from the state?
Sir, I'm looking at the photo, and Your Honor, for the record, this photo will be made a court exhibit?
Yes.
Okay. Phone screen, and it looks like in the upper right-hand corner, it appears the time is either 9:26 or 9:36 a.m.
On my phone, yes, I believe our AV processor, which is the other time of 9:23, I believe that just needs to be updated, but
Okay,
it is approximately 9:26 when the photo was taken.
okay. Those are my questions.
All right, thank you, Mr.
Wait, I'm sorry.
Oh, go ahead.
Decibels are in this room.
I don't. I'd have to pull the same thing up on my phone while people are talking.
Okay, thank you.
Mr. Brooks, any questions for this witness?
Yeah, for the record, I don't consent to being called that name. Do you know anything about the hearing when someone has hearing loss in any of their ears?
I do not.
So it'd be fair to say you don't know if I can hear everything good from this courtroom?
I can tell you what the readout of the room is. Beyond that, I don't know.
Well, I can't see what photo that everybody else is in there seeing that was supposed to be making an exhibit. I have not viewed that, so I don't know what's being referred to when you refer to the picture.
I'll have to show you that in a different way. I don't have the Zoom up and running, which would have been the mechanism to allow for an exhibit to be displayed. I can start that and have that up momentarily. Fair enough. So give me a moment. For the moment, we'll print it in black and white so you have it until I can get the Zoom up. Sure.
You are in the meeting now.
I need to get the other courtroom.
Why are
in, so
they
just
Zoom?
one moment.
You have to hang up after the call.
Will I have to stop the Polycom, Zach?
Yep, you have to hang up and then join into the Zoom meeting.
Okay, hold on, please. Can you do that? Stop the call from Polycom to Polycom, and then I'm going to call it in through the Zoom so I can get your instructions.
Copy that. Hanging up. So are you calling again?
Yep.
Okay.
Except now both the room systems are out, so hold on. One more.
What are they doing? Pause. I was playing with Shadow. I know it's on. Call Shadow. Call.
You are in the meeting now.
All right, so the record should reflect that
I've now changed the audio visual from the Polycom unit to the use of Zoom. I've called in both courtrooms and they can hear from over there. And then I'll do, I just need to get back on so I can get the email. Give me a second, I have to go from double screen to single screen the way I sign in, but that'll take me just a second, and then I'll share screen so the color exhibit can be viewed by the defendant. All right, now the court is sharing screen and the image is being displayed.
Yeah, I see it.
You see it? Okay, thank you. Any questions regarding that then, sir?
My question was, pretty much already answered. You don't know if me myself can hear everything. Correct?
I do not, correct.
Okay.
Okay, thank you, sir. I'll stop sharing. Okay, thank you, Zach. You can step down. Now, I need to get a copy of the jury instructions. They're quite lengthy. The record should reflect that Mr. Brooks was provided with a written copy. It's 107 pages, and the state was provided with a written copy as well. Again, it's all the same, 107 pages, and then my written copy is on its way.
I accept the value and return the value of each document. That's if I'm not muted.
You're not muted.
I also would like to again ask for subject matter jurisdiction to be proven on the record.
Your request is
It
denied.
has yet to be verified. It has yet to be verified.
Your request is noted.
Your Honor,
It's denied without further hearing or consideration.
I was just told that the evidentiary phase is supposed to be closed. How come I haven't been able to present my evidence into the record as I've asked numerous times on the record to be able to do? I've said I have numerous documents that needed to go into the record. Why have they not been permitted to be made evidence?
It goes in through witness.
I didn't rest my case, so I don't know why that's being told. And I have yet to be able to offer my exhibits into the record for evidence. How is that so, Your Honor?
So the court did declare the evidentiary phase of this trial closed. I specifically found that you forfeited your right to present any further evidence or testimony when you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for that reason, I'm denying your request to make them part of the record.
They were not hearsay, Your Honor. I did what you told me to do. You told me, since I was representing myself pro per, that I had to write everything out and present them to the court.
So that's not what I said. You're misquoting me, but in any event, I'm
No, that's
denying
what
your
you said.
request. I
So
said,
you're saying that I So you're saying that I have no right to present evidence and to have exhibits as the state's been able to do?
Mr. Brooks,
Are
I'm
you
not
denying
going to
me
have
my-
a debate about
Are
this
you
now.
denying me-
I have,
are you-
I gotta
are you
mute him
denying me
once
your
again.
right?
So, Mr. Brooks, I have muted you because I declared the evidentiary phase of this trial closed. You forfeited your right to present further evidence and testimony previously by refusing to answer the court's questions. I will specifically address the filings. Number one, it is not true that I advised him that any filing would become evidence. That is simply false. Number two, filings, I told him if he wanted to present motions, should be written down and should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay. Mr. Brooks would have needed to tie regarding any statements that he, from himself, testimony. He cannot simply put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth any exception to the hearsay rule that would allow this court to admit his written filings. I believe without fail they are all irrelevant, not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback regarding jury instructions. It's typically a back and forth. We'll go through them, and I'll ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that, and then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc. Right, you're unmuted now, but but you have to not interrupt.
No, you can't, I'm not trying to interrupt, but how can you deny me the chance to put on the adequate defense by saying nothing that you told me to do can be presented into evidence? So you filed them, you filed everything that I gave to you,
Right,
filed.
Mr. Brooks, I'm
And
going
now
to
all of a
mute you
sudden-
because this is not relevant at this time. He's raised tone of voice, he's very animated, he threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify, which includes the right to present evidence as you would have testified. I closed I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I've referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction conference. It is his choice. But if he is going to spout off about things that I've already determined, I will continue to exercise the mute function on the audio equipment. I'll unmute him again, but you are advised, sir, you need to be proper, you need to not interrupt, and you need to stay on task, which is we're discussing jury instructions, not other evidence, not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions. So once again, I'll unmute him to see if he can follow these simple rules.
You need to tell me why I can't present evidence. How can you deny me the fact? How can you deny me my right to present evidence?
All right,
I
I will
told
mute
you
him
before
once
this.
again because he wants to continue. And again, I understand he's upset. I understand that. But he has himself to blame for his conduct this morning and the rulings that I've made. All right, so let's go through these jury instructions. First of all, has the state received a copy of the draft?
Yes, Your Honor.
Thank you. Mr. Brooks, do you acknowledge receipt? I believe you did by acknowledging it previously, but do you acknowledge receipt of the draft of the final jury instructions?
I didn't acknowledge nothing, and I don't acknowledge anything now. I have not received anything.
I would ask the bailiff to
I
pick
don't
up the
receive.
documents from the floor and put them in front of him.
And
once again.
I'm not presenting it to nothing I don't give my consent to. You can't deny me the right to put on the defense. How can you tell me when I done stated
I'm going to
3 or
read it
4
once
times?
again because, again, I understand he's upset. If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf. I know one of the things I probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment from the amended information on count 70. No, I don't want to do that.
Oh, you don't? Actually,
Hold on. 76.
the box fort.
It's
in the
76
box
count.
fort.
Just want to make. It says near Frame Park, so it is in there. But that was just one question I had. All right.
Here we go.
So, state have any requests as it relates to the jury instructions?
Your Honor, I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far, though.
Okay. Fair enough. There's 107 pages. I certainly can give the parties some time to continue to read through them.
It's not like it would help him, whatever his evidence is. But he deserves it for the way he's been acting. There's your box for it.
Mr. Brooks is requesting to go back to his cell. At this point, I'm going to deny that request. He can remain in the other courtroom.
Here's box for it.
I know he's muted, but I can certainly hear him from this side. He appears to be yelling at the top of his lungs. I can't decipher what he's yelling.
I don't think he really believed he had shock cuffs on. If he really believed that, I don't think he would have acted as badly as he did.
I'll advise Mr. Brooks, without a specific waiver of his right to be present, even if it's from the remote courtroom, he's going to remain in that courtroom. And that would require him to have a colloquy with me.
Just punishing him. Because you know he's going to object to everything they ask him about. He's not going to be useful when it comes to deciding jury instructions. It's just a waste of time to try to involve him. You're just going to make him sit there and listen. Yeah, you know those kids, like, remember in elementary school, those kids they make sit in the corner and then they like make a lot of noise and like eat heavy thighs and stuff, like just to distract the class. Like, I'm in this corner over here. Look at me. That's exactly what he's doing. The mean teacher put me on timeout. I think what bothers me about him the most is that he keeps repeatedly doing the same things over and over and over, and she's answered it over and over. Why do you keep asking?
Mr. Brooks, I know
Why?
you are still muted by me, but I know the audio is working, but I would ask you to specifically advise if there are any specific jury instructions that you are asking be read to the jury.
Like I said, he's not going to participate.
Mr. Brooks, if you have specific instructions or categories of instructions that you believe this court should consider, I need you to write them down on a piece of paper. If you don't have, I believe I see a writing utensil. I'm not sure if I see a pad of paper. We'll make sure you have that. But given your current demeanor, which is still seems quite animated and a loud raised voice, I'd ask that you write it down.
What was that? Oh, he took his jacket off.
How's the state doing on its review?
107.
Okay.
What are they doing? Don't think we should talk while they go through jury instructions? Why are we just watching him behind his box board?
I just want to make a continuing record that Mr. Brooks is still, I can still hear him even though he's muted due to his level, his tone of voice and volume level that he is using from the neighboring courtroom.
Box fort that we still talk about today.
So all of these
And he has his mask on, and he's the only one in the room except for the bailiff.
but they just put them in the numerical order. So you definitely haven't taken out any numbers. There should be numbers. I can figure it out. There are numbers.
Okay.
Well,
I was gonna say there's some like the ones that are in all of ours.
yeah. So that's just the easiest because this goes after credibility. And then.
Okay.
325. Which it's before defendant elects not to testify, and we have to toss up that one. But.
Yeah. On the same day?
Mr. Brooks, I'll advise you once again if there are any specific requests for either instructions or categories instructions that you want this court to consider, please write a note to pass to the bailiffs who can let me know.
And he's still talking. This is the quietest charging conference I've ever seen in my life. Usually they do it out loud. They don't read it silently. What? I don't have my fries yet. Daddy put them on the table. That's crazy. That is insane. He is such a... They should have never allowed him to be so. new trial. I wonder if it's in that courtroom. If it's in that, courthouse. If it's in that courthouse, we'll be able to hear it for it. It said the woman that died was from Waukesha, though, but it happened in another town, but it is in Wisconsin. If it's in Waukesha County, though, it'll be in that courtroom. Courthouse. Courthouse. Not necessarily the same courtroom, but the same courthouse. Next trials of the past is going to be Taylor Halderson. I'm going to do that one. I want to see that.
I know upon my review, I noted a few spots that either in the headings, that some information or words that might need to be removed. But why don't you go through and tell me what requests you have starting, and then we'll go page by page and just tell me what page number and what section.
So I think the first concern I have is with regards to the bail jumping. I know that we had charged, there's 2 separate felony cases. The defendant was out on bail, and I do believe it would be assistive to the jury to have the specific case number. So when we first talking about 61 of 107, we start talking about the bail jumping, and then we go specifically on page 63 of 107, and when we could talk about count 74 and 75, I think it might be helpful to put the Milwaukee case number, because they are different case numbers, so that they know exactly what they're finding, that he was out on bail, and that as conditions of the jury.
So long.
And those bail bonds were entered into evidence.
Why is this day so long, Judy? Why do they have like 4 more hours if it's just charging conference?
Let me look at the information.
And then just, because I think this was just well, I guess I'll have you, when we look at the verdict forms on page 102 to 107 for the bail jumpings, there's verdicts for the bail jumpings for 3 separate counts, 74, 75, 76. I don't think there should not be one for 76. I believe that should be the battery.
That would be true. My computer's just acting up a bit, so I'm going to search. I want to see what the information says. And then I'll ask Mr. Brooks if he has a position on that. Sometimes it's easier if we just list out, I guess, what the changes are requested. I'm going to make some notes, and then we'll go through them one by one. But so,
and I don't believe it was spelled out in the amended information.
Say that again?
I don't believe it was spelled out in the amended information.
Right.
So that would be page 63 of 107, whether or not we want to put the specific case numbers.
Right now, I typically like to follow the information, so I'm probably not inclined to do that, and we can argue that though to the jury. But let's go through the list, and then we'll get the defendant's responses if he would like to give us those. But we'll go through the whole list. So that's the bail jumping.
Yep, and then With the verdict forms with regard to the bail jumping, just to put on the record, page 102 of 107, I believe there's a count 76, which details it as a bail jumping. I believe that should be the battery. I did notice on the motive instruction was incorporated on page 5 of 107. And I know that intent is an element of the battery. I don't believe that was incorporated. I mean, usually it's a standalone instruction. I think the court incorporated it with the first-degree intentional homicide because certainly that was...
I think that's part of the pattern instruction.
Oh, it is. Okay, then we ask for motive. I think that there's a 175 instruction that could be given as a standalone.
I'll look at that. Okay, we'll add that.
And then on page 65 of 107, which is the 70, the preliminary instruction, defendant proceeding pro se, there's the standard paragraph, which is the first paragraph listed under this instruction, and then there's an additional paragraph. We are going to object to that additional paragraph. I think it highlights the defendant's bad behavior. So I'd ask that that be taken out.
Right, I made a note of that. Keep going.
Okay, with regard to page 106 of 107. I believe that those were add-ons at the end that the court wanted to question the parties about.
Yes.
I believe that there was 325 should be given. One of the witnesses for the state did testify. He did have one prior conviction. I believe a witness for the defendant testified that he had a number of convictions. With regard to that same page 106 of 107, instruction 141, where identification of defendant is an issue, I don't know if it is an issue. That wasn't raised during the defendant's closing arguments. His opening arguments. I would know that, or note that the defendant would sometimes cross-examine people on if they were able to see the person driving or the description of the person driving, and he would cross-examine them as to their ability to perceive that. So I guess that would really be up to the defendant if he wishes that to be given. On page 107 of 107, instruction 172, circumstantial evidence, flight, escape, concealment, the state that was included in the initial instruction that we requested, and I would continue to request that instruction be included.
It's really just flight, though.
Correct.
What's that number again?
172.
Yeah, I know, it's just not there. I saw it, it's fine. But only as to flight. I made a correction on it, just gotta find it. All right.
And I would say concealment to some extent, because he took off some clothes that would have identified him. But again, his running away, his trying to conceal his identity by removing some clothing that was identified by numerous witnesses as him wearing a hoodie or a light colored top.
Those are all, and do you have any requests as it relates to instructions that are not in the packet that should be?
No, Your Honor.
All right, let me turn to Mr. Brooks just to get whether he has his list. I'm not asking for a response yet, Mr. Brooks. What I'm asking you for is whether you have any requests for jury instructions? Or in your review, you think anything needs to be this opportunity to verbally advise the court and make your request? Do you have any requests as it relates to the jury instructions, sir? I would note he put 2 boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off, so I can see the outline of his arms, and I can see the jacket on the back of his chair. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so we can
Yes, I think that's fair. I'm going to advise the bailiff to remove the box so I can see Mr. Brooks. I don't know what he's doing behind there. He has quieted down. I haven't heard him in a while. If you could move the second one because it can interfere with the microphone as well. And the third.
Oh, that's the bailiff that was sitting behind him.
Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Complaining because they took his box and threw it away.
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey, man, you don't got to talk to me like that.
Like what?
Do you have any requests?
First of all,
You just talked to him.
Related to the jury instructions, sir.
Yeah, I got requests. It ain't like they gonna be honored though.
As it relates to the jury instructions, sir, what are your?
I heard what the hell you said, man.
Oh!
Well, Mr. Brooks, that was very disrespectful.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
No.
Mr. Brooks, do you have any requests?
I'm tired of my race being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated. How you gonna sit up here and make decisions based on what you think I said when I didn't give consent for you to do any such thing?
Sir, I understand you may be upset, and I really do, but I've made my determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't.
Oh,
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him 5 opportunities.
And then
Mr. Brooks,
explains.
do you have any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
What a big baby.
Mr. Brooks, I know the audio's turned up.
He can hear.
I believe you can hear me.
He can still hear.
You've chosen not to put the headphones on. That's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
No.
Jackass, you're not.
I just told you, I don't know how many times.
Yeah.
I can't hear everything you said.
Then you should put the headphones on.
Don't you understand? You can see headphones.
Have you asked for headphones to be provided, sir?
I should have to ask for them. I asked for my boxes to be moved.
I believe they took them away previously because you were so agitated, they were perhaps afraid you might break them.
I'm seeing. Stop. They think God don't see what you're doing?
Nope, he got them all punched out.
You ought to be ashamed of yourself.
Mr. Brooks, do you have any requests as it relates to the jury
Yeah,
instructions?
I can hear what you're saying. I can hear what you're saying.
You just told me you didn't. So which one is
Yeah, I
it?
got the headphones on. Can't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't start doing with these whole little any sir and all this.
Out of state.
I'm gonna get where I'm
In there
gonna
with
put on
people
this
that
little
knew
act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks. Again.
Being disrespectful. Being disrespectful.
No, she hasn't.
I need to know what your position is regarding the jury instructions. And I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
That's not double.
It is double jeopardy.
God,
How you gonna
you're
charge me with the
stupid.
same charge that I'm already charged with? Says the Fifth Amendment says that you can't place somebody in jeopardy of life and limb twice. I'm already charged with the same count in Milwaukee. This is for the same case. It's the same bail jumping charge. So how am I charged with that here?
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted, but the jury will be instructed regarding the bail jumping.
It can't be because that's double jeopardy. Under the law, if two
You don't
charges are
even
identical
double jeopardy.
in nature, you cannot place me in jeopardy of life and limb twice. You can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
I understand your position. I'm saying it's overruled.
You always want respect. You always want respect, but don't want to give it.
His bail was in Milwaukee. So he went from Milwaukee to Waukesha. So it counts as bail jumping because he wasn't supposed to commit another crime. So he went over to Waukesha and committed another crime. So it counts as bail jumping. I love that movie too. That's a really, really good movie. Yep, exactly.
I'm charged with the same bail jumping charge here that I've already been charged with. That is double jeopardy. You can't charge me for the same
double
exact
jeopardy.
bail jumping that I'm already charged with, that I was charged with before this even came about.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
Okay.
That's the distinction.
Again, there is no distinction. It's the same charge.
No, it's not.
It's the same offense. It doesn't mean it's the same factual basis, sir.
He is not charged with bail jumping with the data violation of November 21 in Milwaukee County anywhere. Further, the double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
Yeah.
All right, so we've addressed that, sir. What other requests do you have as it relates to the jury instructions?
No, I want to know why I'm even charged twice with the same thing. You can't charge me in pursuant to
That's where I got
case
it
in
from.
Milwaukee that I'm already charged with bail jumping for. I'm already
I hear
charged with bail
shaking my
jumping
head
for
every
that
time I
offense.
say stupid.
So you can't essentially say, oh, well, because you were already on bail, we're gonna charge you.
It's a different date of violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond from the Milwaukee County case.
Yeah, but I'm referring to the first bail jumping count. The first. I'm not referring to both of them. I'm referring to one of them.
My understanding, sir, is there's different dates of violations as it relates to that. So I've noted your objection now repeatedly. I understand it. Your request to, I guess, dismiss the bail jumping counts are denied.
I didn't say nothing about count. I said one.
Whether it's one count or both, it's denied.
Am I not being understood? You can't charge me with the same charge twice. You can't.
It's two separate cases, sir. There's two.
Isn't that 971.23? Isn't that the statute? That refers to the double.
All right, sir, I'm not going to have an argument. This isn't fruitful. I understand what you're saying. You're saying there shouldn't be two counts of bail jumping. You believe it's double jeopardy. I disagree with that. They're separate.
I'm already charged with it, though.
This is a circular argument, sir. It doesn't change the fact that, from my perspective, the two bail jumping counts are going to proceed forward. There's been sufficient evidence presented to warrant the jury being instructed.
They can't.
What other requests do you have, sir?
Don't talk over me. Don't talk over me. Just like you don't want me to talk over you. Just like you don't want me to talk over you. Just like you don't.
Mr. Brooks, what other requests do you
judge.
have?
And I just asked you not to talk over me.
You don't get that courtesy.
You've been making your record the whole time you've been over there. You had me muted. I didn't see no requests over there. I didn't write nothing to go over there. I let you do what you was doing. No matter how egregious and biased it is, I let you do what you was doing. Because we both know that what you're doing is not right.
No, we don't both know.
Mr. Brooks, I'm going to refocus your attention to the jury instructions. All of your objections are noted. I understand that. If you can't answer my question, I'm going to move on.
You can't. I haven't given you consent.
All right, I'm going to mute him once again. He refuses to answer simple questions regarding if he has any requests. He just made an argument regarding the bail jumping, so clearly he has an understanding about the law as it relates to that. It may be a misunderstanding about the law and double jeopardy, but he made an argument. I've denied it. I'd like to know if he has any other requests.
That's a misunderstanding. He doesn't.
If he can stay on topic, I'll unmute. I will unmute him again, and he can tell me the list, just like the state went through a list. I need to get through their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here is your opportunity to give me your other requests, not debate with me about prior rulings. Go ahead, Mr. Brooks.
Don't sit up here and try to play no game talking about giving somebody an opportunity that you haven't gave me an opportunity to properly defend myself and put evidence into evidence, which I've asked you repeatedly to do before we even got to the trial. You told me you wasn't in the evidentiary phase.
Mr. Brooks, do you have any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
No, it's not. So please stop being incorrect, Your Honor. Please stop.
Do you have any additional requests? Oh.
That first count 74 bail jumping needs to be dismissed. You can't charge me with two things. You can't charge me with the same charge twice.
All right, I've made a note of that. What's the next issue?
Either one county gonna charge me with it or y'all, but it can't be both. It's the same, it's pursuant to the same exact thing that I was on bill for. The same exact thing, the same exact case. So why are we giving the jury instructions on 2 cases from another county?
I've made a note of that. What other requests do you have?
Man, this is ridiculous. Defend myself, present evidence, do anything.
If you had fired your lawyers,
found a reason for it not to be valid. What are we doing here, Your Honor? What is the
Mr. Brooks,
why should I be here when
I've made a note of your request as to count 74. Do you have any other requests as it relates to the jury instructions?
Why are we even having jury instructions? Why do I have to even sit here in this courtroom at this point? Because everything you've been doing without my consent anyway. So you're gonna find a way to do this without my consent. So why do I need to be here for?
Your objection for lack of consent is noted for the record.
Okay, yeah.
Any other requests, sir?
You talk a good game to save yourself enough space. But everything got put together and has no merit in your court. None.
All right, I've asked him many times. I've advised him, and I'll advise him once again. If he fails to answer the question, I'm moving on. Do you have any other requests as it relates to the jury instructions, sir?
You can't move on because I haven't given you consent to.
All right, he did not answer. So I'm muting him again. The only request that he has made as it relates to the jury instructions, as he pounded his fist once again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability to present a defense, but that decision was made based on his conduct and his conduct alone, as I've outlined already on the record. So the only request that he made was as it relates to the bail jumping counts. I'm denying those requests, whether it be to dismiss one count or to dismiss both on double jeopardy, or to just not instruct the jury. However way I interpret it, I'm denying that. All right, let me go through the state's.
Your Honor, can I add one more?
Sure.
I'm sorry. 154, summary of evidence. I believe we had a map, actually 2 maps that summarize the, we had 3 maps. I think the one was summarized his route, the path that he took. The other one summarized the victims who were struck in the specific locations. And the other one summarized the positions of the law enforcement officers at the various intersections and throughout the parade route.
I'll make a note of that. I don't believe I saw the jury view instruction either. I mean, that was given to them at the time. I don't know that it needs to be
second box
reread, but I think we need to consider that as well. And that was my version of 152. All right, so let me go through the list from the state. Turning to page 61. So I've considered the request by the state. I am going to rely on what information they put in the charging document. I'm going to deny the request to include the specific case numbers. There's evidence, of course, that was received regarding the 2 separate cases out of Milwaukee County that form the basis for both of the bail jumping counts. It will be up to the jury to review the evidence and make a determination as to the verdict forms, though, that were referenced previously, at least the description of them in the jury instructions, that obviously the third count of bail jumping is incorrect. That needs to be battery, and that change will be made. I'm also having Madam Clerk include all of the numbers for the jury instructions when they go back, so it's very clear. Some of them did not have them on, just frankly from prior cases that she and I have worked on, but in this case I want to be very clear with all of the numbers. So I think I've addressed the first 2 bullet points. As far as the motive instruction as a standalone, I believe that is appropriate, and I'll instruct Madam Clerk to include that.
Okay, we're gonna stop. It's 6. We will continue there in the morning. He is an insufferable bastard, isn't he? So I will see you guys in the morning at 8 o'clock. So we will do the rest of, well, we probably don't have time to do the rest. And then we will do closing arguments for the Amber Alert trial, and then maybe start catching up on the Dean trial. So we'll have a busy day tomorrow. I knew you were going to do that. Okay, guys. Be kind to people. Love your family. And Jesus loves you, and so do I. Bye, guys. See you tomorrow.